Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the kid.
Dati mihi Anglican boys, verbal sluppy.
Oh, for crumb's sake.
Scratch all that. Oh, that was terrible. I apologize.
Good morning. Welcome to the Court of Public Opinion. I am the Recovery Addict. Thank you very much for being here today. Hope you got a little bit more sleep than I did last night. Oh, man. I've been up for about 26 minutes now. It's going to be a rough day. I can tell already. Oh, my, oh, my. All right. Well, here's what... we've got a few things to do. Why is that full screen? Okay. I think we're good, actually. Everything's good. Yep, everything's good. All right. There's me. There we go. Sorry, just there's the button I was looking for. A little bit of volume down. All right. Good morning. Good morning. Good to have you here. A few of you seem like you might be thinking, I was just here just what seems like just a few minutes ago. It was more than a few minutes ago. It was a few hours ago. But yes, last night we had an unscheduled live stream, which was a little bit intense. Another news story out of PA. This one out of Philadelphia, and there was rioting and looting, and we were following that live. It was great to have Nick the Hat there with us, providing some information to us directly through some of the sources he has built throughout his career and with the manhunt specifically. So it was nice to have him, and big shout out to him thanks for that. This morning, though, we've got the Maya trial. Let me switch back over here. I'm not awake enough to be that big on your screen. I'm sorry. Oh, all right. We're definitely gonna need a water pour this morning. So we're gonna do that first. Then we're gonna ask and see if anybody has any birthdays. So be thinking if today's your birthday, and then I'll give you a minute to come to that conclusion because it's still early. Shout out to JB this morning from Sharon McDonald. Yes, we have to give away the internet as well. That's something I've been missing. Let's see. Boom. Get this off my plate as soon as I can. Behemoth Monkey. We have this is a first time offense for you, Behemoth Monkey. I believe you're a first time offender when it comes to winning chat. Congratulations, or my condolences, one of the two. I'm not sure. You can tell me tomorrow how it went. But being first in chat has its punishment. It's prize, depending on how you view it. We gift the internet and everything IP related and the maintenance thereof of said objects to the person who was first in chat, and that appears to be you this morning. So we're going to unceremoniously dump the internet in your lap and say, please take care of it, keep it up and running, and everybody who has problems, just reach out to Behemoth Monkey. He can fix them all for you. So thank you very much. Congratulations on being first in chat. That is no small accomplishment. That takes some work. There's the buffer sound. I'm already messing up. Oh my goodness. We're gonna need yes. Oh my goodness. We're gonna need a water pour first. And this might be an epic low as far as on the scale of 1 to 10. I'll let you guys be the judges, but let's see. First of all, here's your warning.
Is that correct?
I almost lost the lid.
There's a lawsuit.
Oh, now we're ready. Now we can get going.
Mike. What day is it, Mike? Guess what today is?
It's hump day.
Hump day! Hey, welcome to Wednesday. A little bit of a warble there on the top end. Congratulations, making it halfway through the week. We did it. Happy Hump Day to you. Yesterday was Hump Day Eve, and that was almost like vibrato. A 6 out of 5. It says Greeners, not bad. 6.5. Sorry, I read that completely wrong. Suddenly it's mediocre. I thought I had done bested the score system. The forward roll out of the car window scored higher. Oh my goodness. I don't know. I've got a couple generous people out there. Lynn Hoke gives me a 10. Anne is more honest and puts it around 6. But either way, it is. Oh my goodness. Oh my goodness.
MT Dufond, you're going to need it today.
Did we determine that you are Yaku? Is this the correct pronunciation? It's early, so I cannot remember. Thank you for the, let's see, Karen Fonseca, or Fonseca. I don't know if that's going to be a Sesha type thing, or I might have butchered it. It might not be either of those two options. Karen, thank you very much. Welcome to the gallery. Looks like that blue courthouse is looking good on you. Thank you so much for your continued support. Let's see, we had a birthday here, Tanya.
Is that
or is it
correct?
Tanya? Man, I'm struggling with pronunciations, and you know it's rough. Paula MC says, Mountain Dew Fund, you're going to need it today. I'm going to have to send one of my kids down to the store down the road and hook me up. I've just got water. Let's see, just made my dog run out of the room. Michelle gave me an 11. Look at that. That's awesome. That's right up there. Kay Scarpetta gifted 5 Recovery Addict memberships. Where's the pronunciation for the birthday? Is there anyone else we've got? Is it Tanya? I'm going to say Tanya. Okay, we're gonna have to sing happy birthday here in a minute. We've got a few minutes before court starts today, and it's gonna be, I predict it's gonna be spicy because the jury's not there, so the lawyers can show their true selves. They don't have to put on this false persona of being kind, of really just being there out of the goodness of their hearts. They're there because they're bloodthirsty sharks, and they're in a shark tank, and it's feeding time. That's why they're here. Okay, the lawyers are going to be the best at what they do, I think, today. That's my prediction. I may be wrong, but let me know. We've got just a half day of lawyering today, which is going to be good. Kim R, I need a nap. Mrs. R.A. stayed up as well, helping Maud because it just got crazy in chat, as it does sometimes. You know, the events didn't help at all either. So to all the mods who were up last night, oh my goodness. First of all, I did not even warn you. I did not send out a little tweet just like, heads up, this is coming. I just went live with, and we have rioting. And and the mods that showed up just handled it. And it was... I don't know where people came from because initially most of the viewers we had were people who had never been to the channel before. So they didn't know the community. They didn't understand our rules or approach or anything. It was just, we had everything from names that YouTube should not have allowed all the way through every type of content that shows the worst in people. And our mods just dealt with it and cleaned it up and made it a place where people could come and get information and be respectful. So thank you very much. Jamie, yeah, you must have been in early. It was pretty rough. It was pretty rough. Okay. Let's see. It is pronounced Tanya, but you say it like Tanya. So I should say Tanya? I'm going to say, I know a Tanya that says that's Tanja, Tanya. And there's a Tanya here. Tanya. Okay. All right, we're going to do Tanya. Any other birthdays today? Why aren't the jury there today? This is going to be some procedural stuff. There are some issues that they didn't sort out before trial began. These might have to do with evidence that's allowed to come in. This has to do with witnesses, restrictions that might be on one side or the other for whatever reason as to how far they can go into certain topics because of, the prejudice versus probative issue. There might be some agreements about allowing in certain documents that don't require laying a foundation. So it's going to be a lot of back and forth. And I think both sides want to get something out of this. It's not just one side saying, hey, can you say it will save us a lot of time if you just agree to this. I think both sides are coming to the table with things they want out of this, and the judge is going to be, personally, I think he's going to be A, frustrated, and B, a little disappointed in the fact that these sides seem to not be able to work together without him there. And a lot of times in a court case, the two sides, he'll say, have you conferred? Have you talked? Before you bring this to me, have you guys just seen if you can work this out? But it looks like everything's going to be brought to the judge. That's just my call. Again, I may be wrong on that as well. Okay, so we've got AJ and Tanya. Let's see. 15 minutes court starts. Yes, we're watching. I've got the audio feed turned up right now. It's AJ. AJ, happy birthday. Happy birthday, AJ. How did I miss you saying that? What was the reason for the riots? I was watching that this morning, and the police commissioner, I believe, said it was not the police officer whose charges got dismissed and possibly reinstated. I still don't know where that's at. He says that wasn't it. They were actually following, there was a group, an organized crime group that literally had rented a truck or had stolen a U-Haul truck, and they were capitalizing on this moment to have this big crime push. And they were going to, I think it sounds like they helped orchestrate or spread the word that this was going to be happening. And so all the criminals who are spineless cowards thought, I can hide amongst other spineless cowards and I won't get caught and I'll be able to get some free Nikes or something. And so they operated like that. And so this group was loading up a truck, and they said this morning that they caught him, that they got the truck, and they've arrested some groups. But the arrest count was like 15 to 20 people. And there were hundreds involved. So, okay, AJ, happy birthday. Is it Sarah birthday? So who all do we have now before we start singing? Because it's time to sing, so we can get ready to go to trial here. C.B. Clark, I don't know Patty Hart's SLA character's name. That's a reference I missed, but I appreciate the effort. Court starts at 9:30. We've got just under 15 minutes. Let's see. Mods were fantastic. So AJ, Tanya, is there Sarah? Okay, AJ, Tanya, and Sarah, right? Last call. AJ, Tanya, and Sarah. Did I miss anything? I have to type these out. There we go. There's the buffer. So now we can proceed. La 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 la. It's always rough to sing happy birthday on days we do the hump day yell, but we'll give it a try. I'm feeling this one. Happy birthday to you. Happy birthday to you. Happy birthday, Sarah, AJ, and Tanya. Happy birthday to you. Sarah, AJ, and Tanya, happy birthday. This is a fantastic day to celebrate your birth because A, it was the anniversary of your birth, and B, it's a great Wednesday, and we're all here together. What better time to party than now, right? Thank you very much. I realize there are a million places you could be and people who would want to celebrate your birthday with you, but the fact that you are here with us, spending time with us today on your special day is not lost on me. It means a lot, and honestly, it's my pleasure. And I hope that something we do can make your day just a little bit better, and hopefully it'll start with us singing happy birthday to you, which we all did collectively. I'll have you know that my special headphones today, I turned all your microphones on your devices that you're watching, and you sang beautifully, everyone. It was wonderful. We had almost 600 people singing happy birthday together. So congratulations. Thank you very much. I did not spy on you. I did not spy on you. No, that's not a thing. All right, 10 out of 10 on the birthday song, says Weather Watch. Weather Watch, thank you very much for being here. Weather Watch saw I was floundering, as I often do, last night on the live stream, trying to keep things going, and he said, hey, Zoom? And I'm like, yes, please. He jumped on and helped us until after 1 o'clock in the morning, at which point he said, hey, I've got to work in 3 hours. I'm going to need to go. So we called it quits then, which was good because it sort of wound down then as well. Thank you very much, Weather Watch. Oh, happy birthday to your husband, Amy. Amy 4369. Happy birthday to your husband as well. Thank you. Party sounds way. Oh wait, sorry. This is the only party sound I have still. I still need to find something a little bit better. It's not that they don't exist. I just have not looked. So, okay. All right. with that said, I think we can do a lot better in chat today than the chat did last night with the riots. But still, let's try to be kind to each other throughout today as we're dealing with some very heavy topics. Interesting side note, I got an update from YouTube yesterday that let me know that in cases that we follow that have elements of adult SA, I know this is a rough conversation switch to go straight from birthdays to talking about SA in court cases, but in cases where that exists, they're going to be more lenient, or where it's adults involved. They're going to be more lenient on the monetization side of things. So basically, we won't get defunded in cases where adult SA is involved, just because it gets brought up, as long as it's not too descriptive. So that said, that was an interesting update. Let's see. Yaku says, thank you so much for the awesome song. We loved you, even though we're in Johannesburg, South Africa. We love that you're in Johannesburg, South Africa, and enjoying us today. It's awesome. Thank you so much. Okay, trial is not up yet. We're waiting for a camera feed. It should be up within about 10 minutes. I think I need a fan down here. It's already warm. Granny the 13 says, packing today to Phoenix to see the grandkids. Oh, and my son and daughter-in-law also. Yes, that also is funny. We know the real purpose why you're going to Phoenix. Hope you have a safe trip and enjoy it there with the grandkids. Hope everything's well. Love it when Recovery Addict hits that low note on the birthday song. Tequila Mockingbird, first of all, I love your name as well. If I haven't told you before, I do. Tequila Mockingbird. It's, like the book. Okay, you guys got it all. I didn't have to explain it. But anyway, I used to sing, like in church when I was singing, I used to drop everything an octave, including the bass line. And I don't know, it stuck. My voice just went down to the basement and decided to reside there. And it works for me. All right, anything else we need to cover today? Does Judge Boyd Flowers arrive in her courtroom today? They arrive tomorrow. Tonight. Thanks, Ann, for the question. Tonight at 7 p.m. on Jay's channel. That's the Shaming of Jay on YouTube. He's going to have the Women Who Rock series with Judge Boyd on it. So that's going to be tonight at 7 p.m. So if you get the opportunity, do definitely watch this. I'm going to try to watch and jump in as well. I'm looking forward to seeing Judge Boyd in an environment other than the courtroom, because I think she's going to connect probably from home. But that's going to be awesome to see that. Okay. Paula MC says, today is my Friday. Don't be mad. I'll try to stream from the lake tomorrow. Oh, have fun at the lake. I'm glad it's your Friday, even though it's my Wednesday. I won't complain at all. It's been a good week. Okay. Rise Above. I watched the documentary yesterday because of this documentary. It was because of this. It was heartbreaking. However, I can't help but feel there was a connection between the severity of Maya's illness and her mother. Okay, interesting. Rise Above, we did a poll yesterday where we asked people who have watched the video, only people who've watched the Netflix video. We said, if you've watched this, who do you support now? And the options were the mother, the hospital, or undecided. And we had 71% say they support the family. Sorry, the family, the hospital, or the undecided. Then underneath that was like 20-something, almost the remainder, 28% was undecided, and only 1% of the hospital. So those that watch this documentary feel very, very strongly. They're either undecided, a quarter undecided, or 3/4 supporting the family. So I guess that goes to speak to the purpose of the documentary, because it was designed to tell the family's message and to tell their story. Teresa says, what was up with the riot in PA? I think it was organized crime that was capitalizing on a public event to sort of go under the radar. But they had an organized crime group, a theft group, that literally rented or stole a truck. I think stole would be the correct thing to say. Stole a truck and had crews smashing windows and grabbing things and loading the truck and taking off with it. They did make some arrests there, and I think they found the truck as well. It might have been the U-Haul that you heard early on. It showed there was a U-Haul early on in this whole thing, and they chased that. Okay. All right, Law and Lumber's breakdown of psychologist redirect was really interesting. I don't think we got the gravity of how good it was yesterday. Lizzie, I need to watch that because some of those things go over my head, and some of the lawyers on YouTube do a great job picking out very important things. I wonder sometimes if what they pick out is caught by the jury. So I'll have to watch that and see what he says. What's the name on Netflix? The name on Netflix is Take Care of Maya. So we have a courtroom feed now. Just want to let you know. So now we need to do a poll on those who haven't watched. Let's do this before court starts here. That's a great idea. So this poll is going to be just people who have not seen the documentary. Okay, so we're building here. Sorry, I can't talk while I'm typing. It's just one of those skills I never picked up. Arguably, I think Mrs. Ari would tell you I can't listen while I'm talking either. So, let's see. And we're going to do the same three options. Okay, so the poll is going to be only for people who have not watched the documentary. If you have watched it and vote, it does throw off the numbers a little bit. I'm not sure if I spelled everything right, but it's early in the morning. Please forgive me. The poll is up right now. We'll see how this goes, and we got about 5 minutes before court's supposed to start. All right. See, I must have lived a sheltered life because I know nothing about this case or the girl. Michael Stevens, it's remarkable. This is one case, and as we had a discussion yesterday with I forget the individual who brought something up. I think it was Cajun something, but he or she was upset that we were covering this trial and not some other very significant trials that are going on. And there are many significant trials going on right now. Some of them are not televised. Some of them are in places where they just don't allow cameras. Some of them have content where basically the cameras would be turned off so much it's not worth a camera crew going there to film. And it's not that they aren't important cases, but they fly under the radar, and because of that, nobody hears about them unless you're actively searching out the information day after day. You mean you listen while you're typing? Not very well. Not very well. There's a chance that I may be wrong on how long this case was supposed to last, and I love what we're hearing so far. But I thought we had 3 weeks, and now some people are saying that might be just for the plaintiff side, that it could be much longer. And I can't imagine it taking that long, especially with how fast they're going through witnesses. We've got 2 witnesses tomorrow that will take a long time, but 2 months, says Katrina. I don't know. I think they blocked out a much more time than they need. What was the last long case where they finished? They were way ahead of schedule. Which one was that? We watched that together. Was that Tommy? Thomas Randolph? What time does court start? In about 2 minutes. We'll have court in about 2 minutes. Scott Peterson finished early. Yes, it did. No. Okay, sorry, I had to. Lawyer, said 6 weeks set for. So they set 6 weeks. Sorry, I cannot talk. Stars Hollow Gumshoe, thank you. You just read what Stars Hollow Gumshoe said, because apparently I cannot. Lawyer, said 6 weeks set for Maya trial. So 3 weeks for the plaintiff and 3 weeks for the defense. The interesting thing in this civil trials, they do have a timer, right? The judge is he's got like a stopwatch. Every time one side starts talking, he counts time towards them, and the other side starts talking, the counts towards them. They do this because they're allowed equal time. And I don't know if they have pre-divided the time, like up to 6 weeks, they're allowed to take that long, or how that's going to go. But the judge is a timekeeper as well. I've got the hiccups again. Carolyn W. saying to Jenny G.A., have you heard of reflex sympathetic dystrophy? Is this... I've heard of sympathy puking. That's as close as I get. And that's a little bit of a reflex as well, but maybe reflux. Don't know about that. I haven't heard about it. Ooh, the garbage man's here. This is very exciting because last week we forgot to take our garbage out. So now they're getting 2 weeks worth of garbage in one run. Flowers for Judge Boyd should be tomorrow morning before noon, Christian Mama. Let's see. Yaku says, apologies, but can you please recap what this trial is about? I've been gone the whole week. Okay, Yaku, this is a civil trial where Maya, who is the daughter, she's the blonde girl you'll see very often on the video. She's sitting in the front with her two lawyers. Maya's brother, Kyle, Maya's father, Jack, and Maya's mother, Beata, or at least Maya's mother's estate, are suing the hospital and the doctors for malpractice, for unlawful separation. There's a huge long list. It's actually in the description. I'll read it to you. It's on our video description. Let's see. They're suing for false imprisonment, intentional infliction of emotional distress, alleged fraud, malpractice, battery. So they're throwing quite a few things at the wall here as far as the things they think went wrong in Maya's treatment. So Maya has a condition that is very difficult to treat and very difficult to diagnose, that just causes random pain and lesions and things like that. The hospital, when they saw it, they determined that, or one of them determined that this was injuries caused by the mother, that the mother was making her sick, and as a result, they contacted DCFS and got a ruling from DCFS through the courts to separate the child from the family or from the mother, and so they then separated them, and then in that separation, which lasted about 90 days, roughly 3 months, the mother was quite distraught and came to the conclusion that the only way that her daughter would get proper treatment was if she was out of the picture, and she took her own life, and then after that the family, shortly after, the family was able to be reunited with Maya. And she's recovered to a great extent. I think she's healthy at this time, but the syndrome may reoccur. It's a tough one. But anyway, so they're suing. They'd have previously sued DCFS.
Please be seated, everybody.
Ooh, here we go. Hopefully that was enough of a... This is the judge, by the way. This is our judge. Artie Bay. Good morning. I wore my escape hoodie on the plane one day and was congratulated on my successful evasion of law enforcement by a fellow passenger. I love it. I love it. That is great. Thank you so much for sharing that.
The webinar started.
I haven't got into the details of the treatments, and there's a lot of arguments about whether the treatments the family was doing were effective or what the hospital was doing were effective. That's part of the litigation here. Maya is not there. Family's not there.
This is case number 2018 CA 5321. Let's go ahead and take appearances, starting with the plaintiff.
Greg Anderson, Nick Whitney on behalf of the plaintiff.
And Tom Elegant, I'm Zoom your webinar, Your Honor.
Chris Altenberg and David Hughes on behalf of Johns Hopkins Hospital.
Well,
we're here.
Did you all have a desire as to how you wanted to proceed this morning?
Probably what we would like the court to hear is, well, I think we could first take up the argument on the proposed jury instruction, which I believe they've been printed out for the court now. Hopefully will be in one moment, our version of it.
My assistant's in meetings, so whenever she's out, she'll get to it. But we can't use my judicial assistant as your assistant.
Well,
because she's got other responsibilities as well.
My clerk is not your clerk.
Share it via Zoom video link. One of our associates should be joining as well for that purpose.
Again, as we indicated, you needed a participant link, which my judicial assistant asked yesterday. So, can someone give me what you want to look at?
Yes, it's very short, Judge, but the problem is it's electronic. And so if there is some place I can email it very quickly, you can have it in 2 seconds.
Well, the problem, again, is my assistant is doing other things right this second.
I can read it into the record.
Yeah. The judge is so
frustrated.
frustrated.
Let's deal with something else while my assistant is doing other things.
Your own outline suggested maybe the motion in limine I presented about the 2015 issue and Chapter 39. And the instruction he has, although it says it's false imprisonment, is really relates to the 39 matter. I suspect that those two things might. The first one probably doesn't take much time, but we could do those two. And then there's about 4 things in the jury instructions that if we know are disputed, and if we can resolve those, I suspect that Mr. Elegant and I can make a lot more progress on creating the jury instructions.
Let's do DIN 3411, docket identification number 3411, defendant J. Hatch's motion in limine to prevent evidence and argument concerning a claim for failure to diagnose and treat CRPS in 2015. Mr. Altenburn, your motion.
On that particular claim, all of a sudden I dropped that file. But we have moved in limine because of the opening argument. The opening argument begins and talks a great deal about medical treatment between 2015 and October 2016. I don't have any problem or concern with that. The situation was an evolving situation that clearly comes in, and conceivably what is in Johns Hopkins All Children's Hospital's medical records on October of 2016 would inform some of the decisions they would make in that time period. But in the opening, it began to feel like he was saying that we should have diagnosed CRPS earlier than we did in that time period, that there was an opportunity to do that we missed, which has never been alleged. And then towards the end of his opening, there was discussion that because there is a theory that CRPS can be cured if it's treated early on, that we could be responsible, that Johns Hopkins could be responsible for all of the damages here because anything that the other 2 doctors did after that point in time would be after the fact of this defendant's negligence as medical professionals. And that's never been alleged, as I've laid out in the motion, not from the first complaint till now. B, they alleged in the last complaint, and maybe the one before that CRPS is a permanent reoccurring disease, not that it's something that could have been cured at some earlier point in time. And finally, had they raised claims about errors in medical standards for 2015 in their original complaint in 2018, the first thing they would have gotten would have been a motion either to dismiss or motion for summary judgment on statute of limitations, because they knew from their own doctors that they had gone to that they believed that ketamine was the solution to this problem. It was the miracle, and they knew that well before 2 years from not only the filing of the complaint, but from when they made their first notice letter. So I'm not asking that evidence not come in. I'm asking that there not be a jury instruction on a standard of care or a theory about a medical negligence claim prior to entry into the hospital as explained in the complaint in October of 2016. and the arguments that we should be responsible for all the damages because our negligence occurred before their doctors ever saw the patient also should be excluded.
Is it Mr. Elgin or Mr. Anderson? Who's going to make this argument?
Yeah. I think this one's mine, isn't it? Your Honor, Tom Elliott again for the reporter. We filed a response, which is DIN 3423, I believe.
He's talking is on webinar. We don't have
This
a
is
picture yet.
the plaintiffs are not making a claim for medical malpractice based on 2015. This is, as we say in the response,
It's behind Elmo.
this is background information. Both sides referred to it. We cite a number of places where the defense referred to what happened before that. So I don't think that we're not going to ask for a line item verdict on 2015. I mean, this is not the instructions in front of you now, but they're in the med mal instruction. If the defense is still planning to blame the earlier doctors, we're going to have a discussion about the level of proof for that. I think it's not clear to us at this point if they're still planning to do that.
I'm going to close out
that
the
will
poll.
also, of course.
Let me ask you this. What am I supposed to do with Mr. Anderson's comments in opening statement that Johns Hopkins Children's Hospital missed 7 prior opportunities to diagnose CRPS?
Your Honor, I think that's relevant to how they handled it when she got there. Having missed it, the jury would be entitled to wonder, to infer
That's an Elmo.
from that.
That white thing is an Elmo.
Maybe
It's a
that's why
document
they
scanner,
wanted to say
document
it
camera.
wasn't.
Where is that covered in the pleadings? Where is that in the 8th amended complaint? Can you point to me any paragraph in the 8th amended complaint?
We're checking out the poll right now, closing it right now.
I'd have to dig in, Your Honor, but
results
I think
are
in the medical malpractice claim, let's look at that.
Beginning, if I may, Your Honor, paragraph 19 under background, which is realleged and reaverred of the 8th amended complaint and follows through with the treatment regimens.
And then 127.
27 as well.
I don't know where the poll went. Oh, there it is. %, sort of support of the family, 33% undecided, and
It
5,
is, as I think Mr. Oldenburg said,
support
part
the
of the
hospital.
story. That doesn't mean it's the plaintiffs are seeking monetary relief for that, but it may explain, in their view, something the jury can consider what happened, or some of the reasons for things happening later.
Hold on a second. 127 isn't backwards looking. It talks about terminating Maya's CRPS treatments the October 7th. And then, was it 17 you said?
And
19, Your Honor.
19.
Which is going to be incorporated, right, that's incorporated into the medical malpractice count.
Right, but nothing about 19 suggests any sort of culpability on the hospital's part concerning events occurring in 2015. The point is that, and as I'm sitting here, I thought Mr. Anderson was trying to allege that we're trying some issue involving 2015 when clearly we're not.
Judge, my point of view, from our point of view, and the reason we put that in is the jury had to know the number of opportunities that they had to develop the information such that in 2016, she was again seen on multiple occasions, and we allege, and so if they knew back then and put it into the records, when she came back in, we're not alleging that they should have identified it immediately. Nobody did.
I think you said they missed the opportunity to diagnose CRPS 7 times.
Well, that's true, and most of those fall in 2016. Now, we're not alleging that in 2015 that they malpracticed by coming in, but I don't think an instruction or any type of motion in limine is warranted for background information. I don't really understand what their motion is it shouldn't be, based on the court's prior comments, it shouldn't be to exclude the entire lead up to what happened in 2016.
I think that's what Mr. Altenburn is saying. It's your pointed comments gave the impression to this jury that we're trying something that's not contained in the pleadings. And he doesn't want that to happen. I don't want that to happen.
So if the ruling is I am not to address, and my experts are not addressing, so the court knows, my experts are not addressing any culpability for 2015. We're not. And I do not intend to raise any further, other than to point out they received information and symptoms throughout 2015, such that by the time they were approaching the October date, they had every bit of information they needed to come in, including diagnoses of CRPS, which I think is part of one of their claims is that, yeah, we did spot it. It was just one of our many that we thought. So having the statement that they missed these opportunities does not mean at the time. It means that they had the information all along. Now, if the court wants an assurance from me that in closing or with my experts that I'm not arguing malpractice in 2015, you have that.
The problem is he brought that up.
What I am arguing is that when she started to have a relapse, when she began coming back in 2016, they were armed with every bit of evidence necessary so that none of this should have ever happened. And that is clearly alleged in the complaint. And that has clearly been testified to over and over again by Dr. Newberger, among others, including Dr. Kirkpatrick and Dr. Chopra. So
he's saying,
I'm not
promise
sure
to be
what
good.
The defense wants. Motions in limine are not to be used as summary judgments, and they're not to be, usually you don't hear about them in the middle of trial. I do not want and I pray the court that we don't have any instruction that might diminish my standing with the jury on that point. If there needs to be an order that says the plaintiffs are not going further to make any allegations or statements from which the jury may infer prior misconduct in 2015, not misconduct, but medical negligence in 2015, then I'm not opposed to that, because that's not a big part of my case. But I just simply want to make sure that I can reference the history of treatment, because that is absolutely pertinent to the decisions they made in October of 2016.
Mr. Altenberg.
Yes, Your Honor. And it seems like we're not very far apart on this at this point in time. So, if he's giving us his assurances, he's not really going to try that. I as an officer of the court, I will trust that. But I do think, as you point out, that I was left with the impression, it seems like you were, I'm afraid the jury was, that we were trying a case beginning in 2015, and a curative instruction that doesn't need to be a long instruction that simply explains to the jury that the medical malpractice claim is a claim for decisions or treatment made in October and thereafter, informed by what Johns Hopkins knew from their own records in the past as well. I don't have, we can work on the language of that, but I don't have problems with that, because I agree, if whatever was not in the universe but was in the Johns Hopkins records on October 7th, 8th, and 9th is material that they probably had access to and could look at. And he can argue that part.
Well, if I may, Your Honor, we believe that this is something that can be handled through the instructions at the end to make very clear. We have no doubt in the ability of the defense to use that instruction to make clear to the jury that this case is about what happened in 2016, not about what happened in 2015. Hopefully the instruction would say, you may consider the information carried forward, or words to that effect, but that's something to be decided down the road. Right now, we object to any order in limine or instruction to the court. I understand and have put on the record that neither me nor my experts are going to raise or testify to medical malpractice, that is a breach of the duty of reasonable care, a deviation from the accepted standard of care during 2015. However, they are going to testify, as they must to lay the appropriate predicate, about the course of dealings and the course of treatment from the first that they got with Maya. They were treating her, in fact, before she ever came down with CRPS, or however you phrase it. They treated her in June of 2015. So that's all background. But we're not going to bring in an expert that says they began malpracticing this case in July, was the first treatment, 7th of 2015.
Well,
October.
No.
Well, because Mr. Anderson has made clear he is not trying that case, meaning a medical malpractice case from 2015. We'll go ahead and take Mr. Anderson at his word for that. Certainly, I don't think Mr. Altenburn was
I just ended the
seeking
poll.
to preclude information about what happened in the lead up. I think that certainly is fair game and relevant to where these pleadings are. But I do not want there to be claims argued that are outside the pleadings. We've spent a lot of time trying to identify what is and is not being tried. As far as any type of curative, at this time, I'm not sure, Mr. Altenburn, I need to do anything. I'll think about it, but I tend to think that when I am instructing the jury as to the specific claims, if necessary, we can put time frames in there. I think that if we need to do anything, we can probably handle it that way.
And for the record, I'm going to leave that to your discretion. I'm not going to object if that's the way you do it.
I think that's probably where I'm going with it right now, so we'll leave it. So what's next?
I think counsel wants to talk about the jury instructions. What we have next is, and it's or a tennis, and I can submit in writing, but we needed a clarification on the testimony of Dr. Kirkpatrick and Dr. Richards based on the court's order of, now where's the back page of the order? Order in limine, I believe.
Did you tell the defense that you were going to be doing this?
I have not filed anything in writing.
I don't even know what he's talking about, to be honest.
I'll file something in writing.
Well, the issue is I don't know if this is a Mr.
Angie,
Hunter
thank you as well.
or Miss Crowells or Mr. Shapiro. I mean, you have Mr. Hughes here and you have Mr. Altenburn, but if it's dealing with something that one of the other lawyers is dealing with, then unless you've told them that you're going to do it, then I'm not sure we should be hearing it right now.
Yes, sir. And for the record, this is the court's, we'll be moving for rehearing on the court's September 22, 2023. And it's really, it'll be rehearing, or more appropriately for clarification, I want to establish the bounds within which Dr. Richards can testify concerning causation, and also Dr. Brewerton's ability to testify concerning the standard of care for the psychologists and psychiatrists at Johns Hopkins.
This is just a lawyer day.
We first started
no witnesses, no jury.
Changed to Richardson's.
No,
But this is where a lot of the fight takes
too
place.
many doctors in that judge. Brewerton and Richards.
So that's DIN 3410. I'll follow your motion. And when do you anticipate those doctors testifying?
Not until later on next week, maybe midweek.
Yeah. So let's get your motion filed and we'll carve out time to address it.
Very good. I just wanted to avoid bringing somebody in or asking the wrong question.
What's next?
I would suggest we try to resolve it, whether to give something on Chapter 39 as soon as tomorrow morning.
Okay. Is there language And I think you gave me something
I have
Friday, and
I gave you something Friday, and there's actually a paragraph from what I did earlier that might also be an alternative. I'm happy to kind of read them aloud to you as well.
yeah,
if you want me to.
because it's sitting in my office at home on that particular piece of paper.
Is this 3420? Docket index number 3420?
It probably is, Your Honor. I don't know that I've got that piece of paper right in front of me at the moment.
Well, it looks like it was filed 9/25.
Happy
This looks
birthday
like
to
a
Princess
2-paragraph,
Buttercup,
but
10
what you gave
MMTHO.
me the other day was a 3-paragraph.
Initially, I gave you one in writing, Your Honor, and I realized I wanted it in the record. So Mr. Ellicott's correct. I went ahead and filed it, and when I did that, I just did the 2-paragraph version of that.
Well,
is what I did.
This is referenced to DIN 3420 for the clerk. And what's written in 3420, Mr. Altman, looks like your first 2 paragraphs and not the 3rd paragraph.
They're very, very close, maybe a word or two off, but basically it says, during opening instructions, I told you that Johns Hopkins All Children's Hospital reported suspected abuse to the Department of Children and Families in good faith, and that the hospital cannot be found liable in this case for having made that report. After that report was made, the Department of Children and Families filed an action against Jack and Beata Kowalski. In that action, the department obtained a court order on October 13 at 2:30 a.m., allowing the department to take custody of Maya Kowalski, subject to the court's jurisdiction. Johns Hopkins All Children's Hospital did not take Maya Kowalski away from her parents. It is not liable for the court's decision to enter this order. And if you wanted to, it could go on, enter this order allowing DCF to take custody of Maya Kowalski. I would point out, by the way, in the one I argued earlier, I had asked for the sentence, Johns Hopkins All Children's Hospital cannot be found legally liable for making the abuse report for the department's investigation of that report, the filing of the department's lawsuit, or the entry of the shelter order on October 14th. The claims in this case do not include claims for those matters. And I had taken that original language essentially out of the partial summary judgment order that you had granted in part concerning the parent agency of Sally Smith. So that language might still be preferable to me because we've already gotten in, well, for example, yesterday, Dr. Duncan talked about getting a big disk of medical records from DCF. Well, she got part of their investigation. The fact that these things are going is beginning to come to this jury. I feel like the jury is probably a little bit lost and confused yet about what the story, how to put the pieces of this puzzle together. And so in some ways, I would prefer to have all 3 of those taken care of now. But if the court only wants to go as far as the taking away issue, the one that I presented in the filing a couple days ago.
Why don't we do this? Why don't you put your language on here? It's not going to help Mr. Elliott, but it's going to at least be able to help Mr. Anderson and me. If you just go up to the document projection, see if I can figure out how to do that.
I do have 3420, Your Honor, so I have the first 2 paragraphs here.
He wants you to go up to this document. Yeah.
You want me to come up here, Your Honor?
Yeah, I'm just trying to figure out how to turn that on from here. I think there's a button you have to push.
My expertise with this is limited, so.
Let me.
The power is on, and power is on. Well, now it's on. Now it's on. Okay.
Your Honor, when you're ready, I do have some comments on this.
Yeah, I'm just trying to get the document camera going.
He's trying to figure out how to turn on the Elmo.
Mr. Hughes, is there a power button? You pressed it, it was red, and then you pressed
Now it's
it,
blue, and there's a
Elmo apparently needs to.
and there's a blue showing this device being on.
Mike, can you help us get this Elmo? I've got it on the lectern right.
Oh. It's up on ours. You need to turn it the other way, though. It's sideways on us. That's better.
Tell me where. Okay.
And you can focus it on the top there by twisting it.
Okay.
I have a lot of Elmo experience. There's a knob.
I continue to have trouble getting the gallery in.
You can make it there, other way.
Well, the gallery screen, so I usually have to turn it off and then turn it back on.
Yeah, I think we
I love this.
work with that.
Let me just do this.
Judge is turning it off and on again. They're looking for a
just-
power button.
I did that on purpose because I'm trying to get the gallery ones open.
Yes.
Turned on. There we go. I don't know why it does that.
Judge just turned on the whole gallery view. Sorry, excuse me.
Okay. And so, Mr. Elegant, we have the original version, what Mr. Altenburn put on, I guess, gave on Friday. So do you have that sheet of paper?
I think I do somewhere, but what I've been working from, I assumed that this 3420 was revised, and that was what we were going to be talking about. So I'm sure I can find the other one, but
I mean, what's on the screen may possibly be a couple words off what I filed, but I'm not positive.
They're pretty close, but what we'll do is we'll tell you what the difference is. But just as an overview, Mr. Elliott, what is your view of at least those first two paragraphs?
Well, Your Honor, we filed a response to the earlier version, and it is DIN 3424. And I mean, the first thing is we don't see why this is necessary to interject this in as the plaintiff's case. I mean, simply saying somebody got records, for example, from DCF hasn't told the jury. I mean, you already told them. You already told the jury in the opening that Johns Hopkins is not responsible or is immune for the report. The jury, I'm sure, will hear over time that the report led to a custody order. But the problem with this instruction, I mean, paragraph 1 just repeats what you already said in somewhat different wording, the immunity. Paragraph 2 is, in our view, way too slanted toward the story that the hospital wants to tell. It leaves out your admonition in the opening instructions that the DCF proceedings do have nothing to do with the plaintiff's claims. In other words, the plaintiff has a claim for false imprisonment. Looking at this, I mean, it talks about, in that department obtained a court order allowing the department to take custody of Maya Kowalski subject to the court's jurisdiction. I mean, are we going to put in there they didn't have permission to do it between October 7th and October 13th? I mean, we have the instruction that the alternative or the addition that Mr. Anderson referred to earlier. It's very short. I could probably figure out how to share the screen here. I'm not sure if that would help for the people who are live, though.
Your Honor, can you inquire of the clerk whether she was able to make any copies, receive it? So it went into your JA. Okay.
The only thing my JA brought in a moment ago was plaintiff's proposed interim instruction on false imprisonment.
That's it.
2 sentences long.
Yeah, that is it, Your Honor. It's labeled false imprisonment, but it really goes to, because it needs to be, the jury, and you've already told them this, but if we're going to start reiterating things, they need to be told, if they're being told again, basically that the hospital has immunity for DCF, they need to be told, and that immunity and the DCF has nothing to do with the plaintiff's claims. So that's what this was an attempt to do, to say, you're going to hear some facts, that's facts and circumstances, that some that are and some that aren't relevant in making your decisions. And talking about the shelter order, which is in paragraph 2, has no effect on the plaintiff's claims I instructed you at the beginning of the trial, and that I will instruct you at the end of the trial, including the claim for false imprisonment. And we could go on and say, you know, in the videotaping and the pictures and so forth, but if they're being told, the jury's being told, well, they were allowed to do this at certain points of time, they need to understand that the order did not immunize them from the plaintiff's claim that they were not allowed to do it at other times.
Paget, thank you very much. Welcome to the gallery. Good to have you here with us.
What's the harm in telling the jury the specific date and time that the court entered the shelter order?
I can speak to that, if I may. That is that it misleads the jury into believing that that one order somehow precludes a number of the, already testimony that has been made in court and will be made through the experts and through the additional witnesses and through Ms. Kowalski. And I'm concerned that there are 5 orders that we're talking about here. We've got orders from October 14th, the original shelter. We've got November 11th, November 12th, January 3rd, January 14th, April 20th, that all change the scope of the custody. Now, they don't release from custody until the 13th, actually, of January. But the concern is, if we start down this road about the effect of orders and only focus on one aspect of it, it will affect all of our causes of action, and especially our medical malpractice cause of action, because the jury and the intentional infliction of emotional distress and negligent infliction of emotional distress, because the jury will be left throughout the remainder of the testimony, and they'll just, being jurors, they'll just turn off to a lot of the testimony, believing the impact of that order on the causes of action is much, much greater than it actually is. The court's already been down this road and has done a yeoman's job of going through all of this to find those parts that are not subject to immunity. To come back in and raise an oblique reference to an order is going to completely, it'll affect every aspect of our case. And so we submitted a very basic one if the court determines it's absolutely necessary for some reason. But all of these issues, first, the court made, we all came up with, and the court read an instruction at the start that was directed towards the first 2 calls being immune. We all understood that. I acknowledged that in my opening. And then I relied on the court's statements in coming up with these and the court's instruction in the manner in which I delivered my opening about what the story was and what they can consider and not consider. And so if we go in at this point, and I beg the court not to submit anything to the jury right now until you've heard more of our case, because there is a strong argument to be made here, Judge, if you'll just listen to some of our witnesses that are coming in. There's a strong argument to be made that none of this should have ever happened had Johns Hopkins diagnosed when they should have diagnosed and not diagnosed when they misdiagnosed. And so I beg the court's indulgence that if you do come up with something here, which we do not believe is appropriate, we think all of this can be taken care of at the end of the case, but if you are going to, please let us get through another week of testimony. I need to say at this point that Dr. Kirkpatrick called us late last night, and he's ill. So he's not going to be able to testify tomorrow afternoon. So we are strongly considering putting Maya Kowalski on if the court and counsel will again indulge us.
Maya
she has some testimony. It is very difficult to get out of her. I know I'm off track here, but the point is I really, really need the court to hear more of this case before we consider focusing the jury on a particular point. From their point of view, the way I was thinking of it, reading this, is they're going to go, what's all this testimony about her not seeing her mom and dad and anything? So, the judge just told us that's all out. That was the impression I got, and I think that this will have an impact on the jury far, far more than what any of us in this room are contemplating. And I'm very worried about it.
Well, let me go back to your first statement.
Yes, sir.
Of your speech there. How is it misleading to the jury to tell the jury the specific date and time of the shelter order? That I don't understand. How could that be misleading? I mean, I was somewhat perplexed when no one said it in opening, talking about the specific date and time. Now, perhaps that's because now you kind of changed how you're approaching this case and not talking about DCF. That's fine. But no one said it to the jury. And so what is wrong with telling the jury the specific date and time that the court took jurisdiction over Maya?
Because the term jurisdiction and the impact of a court order to your average citizen is overwhelming. And because the jury will then conclude that anything that happened after that date is really kind of irrelevant to everything. Because if the court ordered this, why are we listening to any of this stuff? And it will diminish the impact.
The court did order it.
The court,
and so we're not to talk about it now?
We're not to talk about it until we have a chance to put on our rebuttal, and so that this court and the jury can hear exactly what went on with the entry of those orders, and also so the jury can hear the testimony of my experts about how, and they won't, I don't know if they're going to mention the order specifically, but about the timing and the causation and the other theories of the case. That's all going to be, I am willing to wager you're going to get a lot of closed body language and looking up in the air and just kind of not taking notes and looking around as to any of the testimony that goes after that date. It presents to the jury a cutoff date where for the average person's mind, after that, well, the judge has got control. Who cares what happens?
But there are cutoff dates in the pleadings because of how you pled the case and how I've had to rule on the good faith reporting. So there are specific dates and times. And what you're suggesting is we disregard those dates and times, muddle everything together, and then not tell the jury what those dates and times are. I think that's very misleading to the jury.
All right.
So, like I said the other day, we're going to do this. We're going to make a statement, and it's going to include dates and times.
Now,
so
with that,
that's why the other day I said, we're going to do this, come up with something, and your side ignored that. So that's fine. But understand that I said that, we're going to do it, and then you didn't do it.
We did submit something this morning, and let me explain also that
I don't see any date and times on this.
No, it needs dates and times. From our position, it didn't need to have dates and times. It simply had to make the point that at some point the court entered an order. But if I may, Your Honor, if it's the court's position that the jury should be informed of the date of the shelter order, then it should address solely the fact of the false imprisonment, and it should only address, and it should also mention, I will instruct you at the end, the portions of time you may consider for false imprisonment. That is the truth of the matter, is that this really only applies, this order that we're all contemplating here, which is the shelter order. Am I correct in this? And so if the court is of the opinion, and I understand where you're coming from, Judge. We don't want to mislead the jury in any way. That's not the plaintiff's point of view. But it has to be limited enough so the plaintiff has the opportunity to present their case without the jury concluding that, big deal. And there are multiple orders. And so if the thing gets broader than that, then we have to get into all of the timing, because every one of these orders changed the different obligations and times and who could visit and not could visit and all of that, which I don't think is the court's purpose here. The court's purpose here is to let the jury know that a shelter order was entered at this time. I understand. But it should be limited to false imprisonment, and it should have something to say, I will at the end instruct you of those periods of time. Or tell them, Judge, these periods of time, there was no authority under the court's order. And that way, you can inform them and the plaintiffs won't be jeopardized.
I feel that we need to tell the jury the times to which the false imprisonment is allowable and false imprisonment is not allowable.
Thank you, Judge.
I think that is fair to the jury. I think it has fidelity to your pleadings and has what we've been talking about for the last 2 years. So
yes, sir.
I would like an instruction that has the dates and times specifically. Now, I get, and I've indicated this in prior orders, that there are times that Johns Hopkins Hospital is potentially liable for false imprisonment. I agree that there are those time periods. Let's just tell the jury what they are. I don't think we can need to hide that.
Reserving on our position on whether one should be given at all, but the plaintiffs find that acceptable and would agree with the court in that type of wording.
Mr. Alden.
For the record, first of all, the reason I'm asking for the specific issues about taking away is that we've now had 3 lay witnesses who understandably don't understand the details of the law tell the jury that they or Johns Hopkins took Maya Kowalski away from the family. Linda Brown did that as the 3rd one yesterday afternoon. So the jury are adult learners, and you're correct, they need to get this in segments, and that's the segment right now they need to understand, is that we didn't take the child away. The court did that, and we're not liable for that. That said, while she was in the custody of DCF and under the jurisdiction of the court, she was in our hospital. So even though she was in our hospital, that didn't give us immunity if we locked her in a closet for 2 days. And what the 3 things they are alleging is that while she was in the custody of DCF, we didn't release her for a couple days in October. We put her in an EEG room for 44 hours sometime later, and that we put her in a room to take photographs of her for a couple hours in January. Those are the 3 events of false imprisonment. They don't have anything to do with the custody issue, and if down the road the jury, again, as adult learners, need another segment to explain that, I am totally fine with that. And as to the visitation issues, as I've watched the last couple of days, I realize it's not something that we can just give them a one soundbite to explain. And he's probably correct. There's 4 or 5 orders that probably the simplest thing is to put them into evidence, either in their entirety or redacted, because there are some judicial comments in them that maybe we don't want the jury to see. But one way or the other, we can deal with that too down the road. But right now, I'm not prepared to tell you what I think should be told to the jury about about visitation at the moment.
Well, I hear what you're saying, which is a little bit different than what Mr. Anderson and I were just talking about on false imprisonment. Conceptually, I understand what you're saying. The concern is because of the dependency court and the different orders, the status did change at different times. And so
visitation status did
correct.
Change. Right. That's correct.
And so that might be another one where we've got to identify specific date and times.
If you felt it appropriate to give even language tomorrow morning explaining that there are additional orders on visitation and I may discuss those with you further at a later time, I have no objection to that.
I believe that they are trying to put their case in our case through the court. And I further believe that if we simply introduce these orders, we're going to have a jury so confused they're going to be out for 3 weeks. And they're going to have a question a day. You just know it's coming when they try to interpret 4 orders, especially when the end one says, oops, sorry, all this was kind of by mistake. We didn't have enough evidence here. So what I would suggest, Judge, is that we get together, counsel, we do a timeline or figure out how these orders interact so we can come up with an instruction for the jury at the end of the case that says, now, in considering the plaintiff's claims of false imprisonment, here are the dates in considering the plaintiff's claims of allowing visitors, here's what's allowable, or here's the parts that here's what the order said. I think that putting these in, and I understand the defense might be worried, well, are we waiving anything? And for the record, I'm not, I'm taking the position that they don't need to put these in to get the information in front of the jury, and I don't argue either that in any event, putting just the orders in and then having the various witnesses interpret the orders usurps the jurisdiction and the duty of the court. I'm not telling you your duty, but you already know. I didn't mean it that way, Judge, but you know what I mean. It gives the power of interpretation to the witnesses. That's not correct. How these orders interact with the evidence is up to this court. And so I would oppose putting the orders in, and I will stipulate in the record if the defense needs anything to protect them from not putting the orders in. But I think that's the best way to handle it according to the law.
Well, there's a couple of issues that I'm hearing right this second. One issue is Mr. Altenburn's issue that plaintiff's witnesses are coming in and said the hospital took the child, which legally is incorrect. The hospital didn't do that.
Well, they did actually the first 24 hours.
Well, that's a false imprisonment claim, which is allowed, but the physical sheltering of the child is not something that the hospital did. That's something the dependency judge found there to be probable cause for the sheltering of the child.
I understand, but again, I come back to the fact we're talking about the wording of, I think, one or two witnesses about taking the child. The simple facts are that before that order was ever entered, they had no basis for keeping that child, and therefore they took the child and kept her away. And this was the start of all of these proceedings. They did not gain jurisdiction by making that phone call. The hospital did not have jurisdiction. They did not have an order. They had no legal cause. They had no reason. Now they're going to argue, but they had no reason under the law to take Maya away from her parents to start with. If I understand the court's interest in saying a shelter order and parts of this thereafter are actionable and parts are not, I get it. But insofar as that wording is correct. And there's no need, in my view, to correct and take away and diminish from the fact that from the first part here, they didn't have squat for legal authority to take this child. They made that decision up, and if the court will allow, and that's why I'm hesitant to even, I'm begging the court to hear more of our case in this regard. But once the evidence comes in, I believe it's going to be very, very clear the reasons why and what they did to the child had nothing to do with whether they believed she had a victim of Munchausen by proxy or whatever it morphed into lately. And so I really think the court needs to hear more of that case, and if it needs to be set out, the specific dates that are not actionable, fine. I still say that that's something for the end of the case, and I relied on that in my opening. So what I would propose right now is that we be given the opportunity to develop an order. Now we understand the court's position, but that we should not be obligated to backtrack on testimony that was technically true. It was true. They did not. They kept this child because they stated AMA, and we can prove, if I had my enlargement here, I'd prove that they specifically said a patient here can leave at any time. And that was in their rules, which we'll put into evidence, and that was in their protocols that we'll put into evidence. So they violated their very own internal rules by keeping that family their AMA. AMA, against medical advice, has no force of law, none. So they took Maya and took her away. What's wrong with the witnesses saying they took her? I don't think that's necessary, Your Honor.
Well, let me hear from Mr. Altenburn, and then I'm going to tell you where my thoughts are.
As to the period between 7th of October and the entry of this order, I think there's going to be disputed facts about time periods and whether she could or couldn't leave the hospital. And so we do probably need to hear evidence on that. The testimony I've heard, especially like yesterday, was Beata called this woman and said they've taken it away. They're talking about the shelter order, not this earlier point in time. And so as to this earlier period, I'm sure that the evidence will be developed, but it wasn't that we, again, the issue of whether we took her away from the family is not something that is being accurately explained by the questions asked and answered by the witnesses in this court, and we needed an explanation of that. And so I believe that this is an accurate explanation of it.
This is where I think the testimony, I think there's enough testimony in now that it's important that we give the jury some context in how it should be evaluating the testimony that's coming in. Specifically,
this is a big win for the hospital.
We need to identify the periods of time associated with the false imprisonment claim. I also agree with Mr. Altenburn that the entry of the shelter order is not the hospital taking the child away. And I think that needs to get made clear to the jury. Because contrary to Mr. Anderson's argument, I don't want to have this perpetual testimony over and over and over again on an issue I know I'm already going to tell the jury that the entry of that shelter order is not taking the child away, is not the hospital taking the child away. I already know that. I know I'm going to say that. So I am fine doing it in one combined instruction if you want to break it out into multiple instructions. I do think, although I don't think we need it tomorrow, I'm not opposed for it tomorrow, but I do think at some point we're going to have to identify for the jury the changing nature of the dependency court's orders, and again on time frames. Now, one other corollary to that, which was referenced, and I agreed with Mr. Anderson the other day, and I still agree with him, is sometimes the order said X, and then there is either an interpretation by the hospital or a request to, I want to call it HRS.
DCF.
DCF now. To DCF. That isn't part of the court order. So I'm not, right. I don't think that portion should fall in my instruction relative to the nature of the dependency court's order.
And
if we get a pause here, I'll try to explain this.
And I think I'm not disagreeing to any great extent on that, that the order, the shelter orders are a standard order, and the other orders, I know that there's actually evidence that Ms. Beatty called to get explanation because two sentences seem to be inconsistent ones. So to some degree, it's going to depend upon, I'm assuming this is all coming in on intentional infliction of emotional distress, by the way. It's not an affirmative defense that I've got, but it's going to have to come in as, whether we, I don't know whether negligently is the right word, but whether we properly implemented these orders when we received them. And there certainly is going to be some disputed evidence on that issue.
And at the end of the day, I'm going to look to the lawyers if we're going to put the orders in, or it's going to be an instruction, or both. But I do trust the jury, so I am, when in doubt, I'm going to put the order in. If y'all are on a jump ball, and I'm probably going to put them in. Whether I do it with an instruction that kind of explains, I might do that.
And I provided that instruction earlier. They had all of them in it. It's a hard read. I'll put it that way. I don't know that I would want to read that to a jury if I was sitting where you were sitting.
Okay. So, given my statements, Mr. Elliott, hold on a second. Sure. Given my statements, do you, and I guess this is a Mr. Altenburn and Mr. Elliott question, take my statements and try to fashion something, or are we sitting here doing it by committee right this second? in open court.
You want something like what we have now, but also has some explanation of the false imprisonment periods in it? Is that what you want?
I want to identify dates and times. I do not want to give an impression that the entry of the shelter order immunizes the hospital from conduct, because clearly that's not what is the court's intent.
Okay.
So, and I think that was where Mr. Anderson was going. He didn't want the instruction to have a judicial gloss that the jury would then disregard evidence.
Rather than trying to do that on the fly, if Mr. Elliott has time, I would think this afternoon he and I can get on Zoom together and probably get very close to what you want.
That works for me.
Okay. Thank you. Now, Mr. Elliott, was there something else you wanted to say on this issue?
No, Your Honor. I think you just covered it there, because you reiterated that we need something more than these two paragraphs. We need something that says, look, this doesn't affect the other claims. It doesn't affect the claims the court has found are viable to go forward for the jury to consider. So I think we need some, let's see if we can work out some language on that. And I'll talk with Mr. Anderson and Mr. Whitney before that, so we're all on the same page.
Okay. Let's change subjects for a second. And, you know, Mr. Hughes, I don't know, I assume it's going to be, well, I don't know who's going to do the cross of Maya Kowalski, but are you telling us, Mr. Anderson, that Kirkpatrick's not happening tomorrow and we're having Maya Kowalski?
Let me tell you exactly what I know, again, as an officer of the court. We received a phone call. Dr. Kirkpatrick is vocal about when and how he wants to testify, but last night we received a phone call, which I was able to return this morning, in which he informed me that he has some kind of bug, as he put it. It actually sounded in the background like he did have digestive problems. Anyway, I take him at his word. So I asked him how long. He said he didn't think it would be good for him to come in anytime over the next couple of days. That leaves me with a big hole in my case. Maya Kowalski is a possibility to come in. Her testimony would be limited, and it would be limited to really the period that she was in the hospital and those events. And frankly, the reason, Judge, is that right now the jury has not gotten a big picture at all. They think this case is about a statue and not being able to pray. And so what we wanted to do was to put her in for a given period. The alternative is this. If the court says, no, it needs to all go at once, and we'll hold her out and we can play depositions and maybe find one live witness for the afternoon. We have Dr. Chopra. He may take it into the afternoon. So that's all I know.
Well, let me throw this out. And Mr. Hughes, I don't know if your other folks are listening in or if you've got the ability to convey a message to them, but I was going to talk about our schedule for next week. Friday afternoon, which I guess is October 6th, and I think that's one of the days that we previously talked about, which was a maybe. Mm-hmm. The afternoon, we're not going to be able to have court. We can do court in the morning. Because we seated a jury faster than I anticipated, I feel like we're ahead of our schedule right this second.
This is good news for all of us.
So I was going to suggest and get the lawyer's view about, if we take a half day on Friday, do you want to take a half day sometime else during that week? Or do you want to just take all of Friday off? Or do you want to leave at 4 o'clock on Monday through Thursday? Or now, if we've got an issue with Dr. Kirkpatrick, if your other doctor, and I forgot, who do you have else coming in?
Chopra is coming tomorrow from Boston.
In the morning?
Yeah, I hope. He's supposed to fly in this afternoon.
Okay, so assuming that he goes in the morning, do you want to take the afternoon off and then just not take a second half day next week? Or what are your thoughts as far as how to proceed?
Let me be frank, Judge. We have to fly in a lot of people, and because of that, and because schedules constantly change, we could use a day off now and then to prep and to get these people in so that this thing moves through efficiently and without a lot of
That's Maya's dad right
with
there.
exhibits and so forth. So
that is Jack.
Taking off at 4 o'clock on the days we're here doesn't help the plaintiff that much in terms of, because frankly I'm pretty burnt by the end of one of these days. It's hard to stay up late and adequately prepare witnesses. So I could use a day off about every week. I believe that we're way ahead of the schedule, and that's all I'll say.
You
might get a 4-day weekend.
All day on Friday.
3-day weekend.
Bits and pieces as well.
Okay, but if we do all day Friday, then that means effectively we've got Thursday, Friday, Monday, Tuesday, Wednesday, Thursday without a break.
That's right.
We prefer a half a day on Friday and a day sometime next week. Actually, when we first started talking about this, before it morphed into 8 weeks, the court was contemplating taking Fridays off. I don't know that we need to do that. I don't know that we're that far ahead of schedule. You're keeping count better than us, Judge. But from the plaintiff's point of view, in our case, this trial is going to go a lot smoother if we have at least a half day and perhaps a day now and then during the week.
Okay, so why don't you get with Mr. Hunter and kind of get an idea as
the lawyer
to
on Zoom is from the plaintiff's side.
Week. You know, I feel, and I think this is kind of one of the things I said earlier, is when you have a really long trial, I mean, this is a marathon. It's not a sprint, and I want the lawyers to be able to do what they need to do outside of court, and I recognize that there's a lot of work that has to be done outside of court. So I am fine if we take 2 half days next week if you want to make it a full day on Friday, but it just seems like that's a lot of court days between now and then when we've got a little bit of time that we could allow for a little bit of flexibility.
To be clear, I think Mr. Anderson was maybe talking about half a day this coming Friday, but that's not what you're talking about?
I was talking about next Friday, October 6th.
Yeah. We prefer a full day off. That's better for us in terms of getting people in and having the time to coordinate the witnesses with the exhibits and figure out. And remember, we still have a bunch of exhibits we need to work through with the defense and perhaps with the court. So, extra time is always good. We'd prefer to have a half a day this week only for scheduling purposes to allow us to figure out. I prefer not to put on Maya Kowalski this week. I think it would be better for our case if we did, but I think it's going to be a long process and it's highly emotional. So
what about this? And Mr. Hughes, I don't know if you've been able to get a hold of them, but what about assuming Dr. Chopra's plane arrives on time, that we do Dr. Chopra tomorrow, and then we can spend the afternoon hashing out whatever Mr. Altenberg and Mr. Elegant resolve tonight on this instruction. And so you would basically have a half day of testimony tomorrow, full day on Friday, and then we'll just...
I only stood, Your Honor, because we also have a physical therapist that has arranged her work schedule to be here first thing in the morning. She won't be a long witness, so that's just a heads up that we prefer her and then Dr. Chopra.
But she won't take long.
That's fine. And if we have to, finish them up an hour after lunch, I mean, the idea is to give you a little bit of time on Thursday. I'm just thinking that this might, because of the Dr. Kirkpatrick sickness, and I will tell you, and I'll tell us again, I think since there's a lot of people in this courtroom and a lot of people out and about, that if someone's sick and if we can rotate their time to a little bit I think everyone would prefer a person who's not feeling well not come in.
Yes, Judge, we agree 100%.
The worst thing that's going to happen to us is if you all got sick or the jury got sick, then we're in serious time issues then.
Plaintiffs agree.
So just so I'm clear, because we're going back and forth, the plan for tomorrow is Chopra
and it's Rachel
DeYoung, the assistant? Okay. That works.
How long do you estimate that Chopra will take on you, correct?
Obviously, depending on rulings, I would expect my direct to take an hour and a half, maybe a little less, and if there's a lot of discussion, it could take 2 hours, and then that would give you an hour and a half to cross.
Now, that would hopefully allow Mr. Elliott and I to address 39 and maybe a couple of things that I don't think we're going to really reach today. I might take a couple of low-hanging fruits, and I would like to try to resolve what the instruction on intentional infliction of emotional distress for suicide looks like sooner than later, but I don't know that we're really going to have time to do that the way things are going this morning. So
that is a problem for tomorrow, but we'll solve it.
Well, I mean, I definitely want the instruction on false imprisonment and your issue. I really want it resolved tomorrow, so conceivably it'll be given on Friday to the jury.
I think we can do that, Your Honor. I thought we were going to try to address the intentional infliction suicide instruction, and which I think we're close on. With the court need to make one call, and then the instruction on punitive damages. I'm ready to talk about those if there's time, but if there's not,
I've got the time. Do you all want to do it right now?
I'm happy to do those two. There, on a parent agency, there was a really minor issue as well. We might be able to get all that done.
So, what number am I looking at? What din am I looking at this point?
May it please the court, we've got witnesses to prep. May we leave this in the capable hands, Mr. Elliott?
It's fine with me.
Thank you.
And the attorneys are leaving.
Your Honor, 3425 is our memo on giving the standard punitive damage instruction. And it was in sort of further response to a more, what would you call it, multiple issue memo that the defense had filed about instructions. And I think
I'm going to try to explain all this as soon as they're done. It looks like they're actually wrapping up pretty soon.
You didn't plead certain things, so you can't have an instruction, the punitive damage instruction on that. But actually, we did because we point out the plaintiff's 8th amended complaint on paragraph 26.
Well, perhaps, Mr. Elliott, what will be helpful is if I hear what Mr. Altenburn's concern is. And then we'll get to your response.
Okay.
Is that doable? So, Mr. Altenburn, what DIN number do you want me to go to at this point?
The
attorneys have left the building.
Instruction that we proposed is in 3397.
3397.
And I think the legal arguments are such that you probably don't need to look at that. And the punitive instruction there is going to be on about page. Well, it begins on page 15 of 49. It's a little off because it contemplated that Ms. Beatty would be a party at the time. But the critical thing is, and the distinction between us, is that they want to have the instruction based on the standard language coming out of section 768.72 with the 3 things that can make corporation liable under the statute. But in this case, and those things are that the corporation actively and knowingly participated in the conduct, or that officers, directors, or managers condoned the conduct, or that the employer or the corporation engaged in gross negligence and that contributed to the loss, or the three standards in the statute. When they filed a motion to amend for punitive damages, you entered an order saying that they were entitled to amend. We appealed that. That's been resolved, and that's not what I'm talking about here. But
does anybody have the case number on this?
When they chose to amend their complaint,
Trying to pull up some documents.
This court entered an order, their chosen language was not the language of 768.72. Instead, in the complaint, in the first two counts, which were the only ones involved, for example, in one of the interlineations that sort of was amended into this in paragraph 74 is that the actions of all Children's Hospital were willful, wanton, malicious, and evidence to callous and intentional disregard for the life, health, and well-being of their patient mea culpa, which actions and or inactions as pled herein are substantially contributed to grievous physical, emotional, and psychological injury to mea culpa. Now, when this case came up for trial a year ago, May, I pointed out then that the jury, I couldn't do the standard jury instructions based on the statute because that's not what they pled. They pled a different standard for that. And at that point in time, I'm sure they didn't want to amend because they were hoping it to go to trial, but that did not happen. And since then,
sorry, Sharon, I just deleted
amended,
your message.
I believe twice. We're on the 8th Amendment complaint, and they've never ever changed the language of punitive damages. So my position is that they have elected to have as the standard for punitive damages the language in their complaint, and that doesn't fit the statutory language at all. And if your Honor disagrees with that and says we need to use the language from the statute instead, well, this is a claim for punitive damages is not a just add-on element of damage. It's a separate claim for punitive damages. It's supposed to have been pled under Rule 1.110B, I believe it is, so that it states a cause of action and it contains a short and plain statement of the ultimate facts showing that the pleader is entitled to that relief. And none of these elements were really pled in that action. The one I'm probably most concerned about is the subsection C of the statute, which is that the corporation engaged in conduct that constituted gross negligence that contributed to the loss. But there's not once that they even use the legal conclusion of gross negligence any place in this complaint. The counts we're involved with here are counts that the employee at least was engaged in intentional conduct. And so I don't want to have them trying to prove up some gross negligence claim that they've never had a pleading on at all. So I think that they have elected the language they put into their complaint, and that's the legal standard and the factual basis for their punitive damages claim. But if not, then at least when it comes time to evaluate this, it's not all three standards from the statute.
Mr. Elliott.
Okay, Your Honor, our response is that 3425, docket index number. And sort of preliminarily, of course, we have, unlike the suicide situation, we have a standard instruction, and the presumption is you give the standard instruction. Then we move on and we note a case that says, the complaint is a tentative outline of the position the pleader takes before his case is fully developed on the facts through discovery and evidence. Cite the case for that. Now, and then the statute itself, 768.72, draws a distinction between pleading and what the jury then considers. So those are two different things. But I think the main difference here, or main thing that's being overlooked, is that the plaintiff's Eighth Amendment complaint, which is 2816, if you look at page 6 of that, 26. When the plaintiffs are pleading for punitive damages, they say, quote, based on the actions and outcome described in this court's order granting leave to allege punitive damages, and the factual underpinnings are incorporated by a reference. Your Honor entered two orders. The longer one is there's one at 2034, and then there was one on clarification, rehearing, and so forth, reconsideration at 2103. And we've recited in the memo here, Your Honor goes to great length in there to describe some of the actions. On page 4, talking about that Beatty was acting, and I guess there's some similar names. There's a risk management committee and a risk management department. And as I understand it, I think while the risk management committee, which had a lawyer on it, apparently knew of some of this stuff, I guess they weren't the ones that were hands-on directing. The risk management department was. And Your Honor goes on in page 8 of that longer order, talking about what was done and what Beatty testified to. She's told to do this by the risk management department. Well, that's management. I mean, I understand there's been some discussion that, that department just had a bunch of retired nurses or something like that on it. It didn't have an officer on it. Well, Your Honor, if they take a committee or a department that's going to be in charge and dictating orders or providing instructions to people, and they want to staff it, I really don't care who they staff it with. They've given them authority to tell Beatty to do these things. And again, Your Honor recites some of those things in the order, and then those are incorporated by reference. So there is this greater detail that we're hearing should be there, is there. It's incorporated by reference from your order. So I think we are there. We should give the standard instruction. That's what's presumed correct. The requested instruction on, I guess page 16, just wants to talk about whether Beatty was a manager. I mean, that's where that's going. And that's not what this case is all about. So we think the standard instruction is warranted. We think it is pled enough, not that it needed to be pled in exact detail, because the pleading, again, is different from the issue the jury decides.
Anything further, Mr. Altenberg?
Your Honor, first of all, whether it's one risk group or another risk group is probably an issue of fact that we'll have to figure out down the road as the testimony comes out on that. But and Mr. Elliott is talking about the language of the wherefore clause in 75.
Sorry, guys, I'm trying to find the complaint, the actual complaint. There's piles of documents.
I'm relying on my memory, but I'm pretty certain that the language for punitive damages based on actions and outcomes described in this court's order granting leave to allege punitive damages was actually stricken from this complaint by you at some point in time.
I think the family did sue and got $2.5 million. Thank you, Jackie, for that.
Pleading, so I don't know that that's actually even there. But one way or the other, the punitive damages statute, rather, in subsection 1 talks about the process of getting the right to amend, but it doesn't contain language about what you put in it or choose to put in your amendment. And what they chose to put in was simply that these legal conclusions about willful, wanton, and the like, rather than telling me that someone was grossly negligent or the like. So I don't believe that they're entitled to the benefit of a statute when they didn't plead the ultimate. They didn't plead that as a legal conclusion at all in their complaint, and they didn't lay out the facts other than perhaps some facts that may go to one prong of this.
Having reviewed my orders on allowing punitive damages and then the order on the reconsideration that Jay Hatch filed, I am comfortable that the gross negligence is included, and therefore that variant would also be subject to being instructed upon, obviously depending on what actually comes in.
Sure.
So I guess what I'm ruling, Mr. Altenburn, is I disagree with your position that the pleadings preclude that variant of punitive damages for just those two claims.
And therefore you want the final instructions to be based on the statutory language rather than on the pleadings.
Exactly. Now it looks like you have other items in here. I don't know if those are disagreed to or not.
As to punitive damages, I suspect that Mr. Elliott and I will probably end up that this was the big fight. So I think we can probably work on the standards at that point in time. Because you just told me you want the gross negligence standard in there, and one of the concerns was which elements. So at least for purposes of now, we'll probably put all three elements of the statute in pursuant to your order.
Because I think in my order I indicated that the proffer was sufficient for any of the three variants.
I think you did, yes. My position was that after you told them they had the opportunity to plead that, you didn't.
I understand.
Okay. Thank you, Your Honor. I think maybe next is I think it would be useful to the parties to have a determination on I guess we'll call it the suicide or intentional infliction standard. We're proposing language, and it is, I'm looking for in our DIN 3401, we have an Exhibit D. 3401.
I think I've got the complaint. It's 90 pages long.
Let me know. I'll wait for you to get there.
I'm at 3401. Just Exhibit D, you said?
This is Exhibit D, which will be a ways down, because I think Exhibit B was the instructions we were working on with some comments. But Exhibit D is just one page. And it's, I think Mr. Altenburn had prepared an instruction that parts of we were okay with, but then his instruction, I think, referred to a California case, and that the plaintiff or the deceased had to be suffering from a mental illness or something along those lines. We found two Florida cases that talk about, if there's a quote, when you get to 34OD, you'll see there are quotes from both cases. 3401 Exhibit D. There are quotes from both cases. There's a Florida First District case.
Just so I'm clear, is that the Nelson versus Seaboard?
Yes, Your Honor, it is.
On there.
That quote that the person being sued had to have driven the deceased beyond the point where she could rationally decide against killing herself, and then that case is then cited in a more recent federal case, and they agree with that, and then they refer to such severe stress and emotional upheaval that she killed herself in response to an uncontrollable impulse. So the Florida case law, our position is, does not require the person have a mental illness. You can have, and if one just sort of steps back, I think, and thinks about it from a common sense point of view, not everybody who commits suicide has a mental illness. I mean, some people do it, for other reasons, that, they feel overwhelmed for whatever. It could be a variety of things. It could be financial, it could be emotional, it could be family, and in this case, it was family. And those people don't necessarily have a DSM or whatever mental illness. And so we would argue, and there is, I think we agree, both sides agree there's no standard instruction on this, but that we think that when it comes down to describing this part of it, it should be the Florida law and not the California law.
Thank you, everybody who's pointing me in the right direction to help me find these documents.
Your Honor, I filed a fairly extensive memo on this, and I apologize on my own version of this. I don't have the DIN number, but it was filed on September 6th of this month at 9:53 a.m. It requests
that's DIN 3346.
3346. And basically, Mr. Ellicott is right that not only is there no standard instruction on this, but I think the best of all of our research, none of us have found a case that went to trial on this issue any place in the United States.
They all settled.
So the case law that he's relying upon, and the case law for that matter that I've given to the court from other states, is cases that are primarily discussing, well, did it pass a motion to dismiss or did it pass a motion for summary judgment or not? In many of the cases, it did not pass those things. And so this case law is, I think, helpful to the court, but the notion that anyone in the United States of America has something that they've settled on as the instruction to give to a jury in this case just isn't there. So this is
it's a groundbreaking case.
The hardest and biggest legal issue for both sides of this case, and the most likely issue to be one that we would raise on appeal one way or the other.
And is your proposed instruction the one that's at the bottom of page 2?
Bottom of page 2.
Of your memo?
No. Actually, the memo goes forward and gives you 3 instructions at the end, because I believe that the instruction should be limited. If I can kind of just go through this very quickly.
Yes, sir.
Everybody here and in all the other cases around the country agree that there's something more you need to say to establish a claim for intentional infliction of emotional distress that results in suicide, because of the strong common law presumption that suicide is an intervening break in the chain of causation. Those cases clearly, as a result, are focused on the concept of foreseeability. Some of the case law is discussing it in the sense of, well, what's sort of the duty you owe to another person here that would be such that it would be foreseeable that suicide could occur. And some cases have focused on, well, does the conduct cause the suicide as a proximate cause concept, not of the damages, because once the person is dead, the wrongful death damages are a fairly easy proximate cause issue. So my position on this is, if you look at Tate, which is the case that they relied on from California, is one of the, if not the earliest case, one of the earliest cases from about 1960. The whole focus there is on this being a tort of intent.
If it's all right, I'm going to turn this down a little bit as they argue the finer details at this point.
And so I'm
going to try to explain what's happening so far.
Is one that is
there anyone who wants to continue listening and wait for the break?
Before a motion to dismiss, and you did not really accept this, so I'm not expecting that you're going to say, yes, I'm right. But because of the nature of this tort, and especially in this attenuated situation where the tort is somewhat difficult to explain in terms of outrage just as a basic tort, keeping in mind that we have no right to comparative negligence, we have no right to contribution from anyone else. This tort puts us, because it's an intentional tort, on for the ride for the whole 9 yards of damages.
Here we go.
The standard for this should be...
We're going to turn him down for just a little bit as he keeps talking. What is happening right here, the reason we have this day without the jury is because as the case began, the plaintiff put forward an argument or use specific terminology in the opening of the case that basically caused the defense to say, hey, we need to address that. Usually they try to rule on everything. They try to foresee what issues will come up, what topics will come up, what areas the case is going to go into, and they will fight with motions in limine, meaning they'll have a motion saying we want to restrict this from coming into the court, and that'll be decided beforehand. But in this case, some stuff has come up during the trial that defense has now said, hey, we need to file a motion in limine to say let's not go to here. And in other cases, they say the way that the plaintiff is arguing this case and the way that the evidence is coming into the trial is such that the jury's going to be confused, and we want the judge to say, hey, just for your information, when somebody says they took the child, we want a distinction, saying it was CPS that took the child. It was a court order that took the child, not the hospital, even though the hospital was sort of the action arm of that, but it was under court order. They want to draw that distinction so they can separate themselves from the bad people, right? The plaintiff does not want to do that because they're saying it's not so cut and dry, because you have to look at CPS just didn't come in out of the blue. The hospital took all these actions and got CPS to do this, so they're party to this, and so they're trying to separate this. The plaintiff definitely wants all this evidence to come in first before the judge makes any ruling, because if the judge comes out right now and says, Mr. Attorney here is on the screen, who's still talking, and he will be talking for a while yet, I think. He wants this curative instruction saying, separate us from CPS. We were not the ones that ordered this. CPS ordered it. We just had to do what the law said. If he comes out and says that, and says at this point, at this day, this is where the CPS, where the court stepped in and said, must be separation, then the hospital sort of is like washing their hands of everything. And plaintiff's worried that the jury will sort of disregard anything that is testimony related to, after that time frame. And so the plaintiff, Maya's attorneys are saying, this is a huge part of our case. You can't say this, or else they'll just disregard everything, because we think there is a connection. We think there is a problem. It's not. Yes, the court did have a specific date where they made this motion and they made this ruling, but it doesn't apply this way. The fact they're arguing right now that the two main lawyers for Maya have left, the only one left on the plaintiff side is on Zoom. But they're arguing right now about a instruction that will be read to the jury about the law regarding the liability of the hospital in relation to the mom's taking her own life. And they're basically saying that we haven't had a situation like this where we say this exact case has come up in the U.S. before, and here's the instruction the judge used to the jury then. In all the other cases, either the case was thrown out, where the judge said, sorry, you don't have any standing here, or there's no law, there's no recourse for the family, or in other cases, the attorneys settled outside of court. They said, instead of going to a jury, we're not going to admit any wrongdoing, but we're going to settle. So this is the battle they're fighting. And even though it's very monotonous and it seems very detailed, it's in the weeds, this lays the framework for how the case is allowed to go forward. Because the judge is going to make some rulings. Oh, apparently it went black for a second. The judge is going to make some rulings here on the motions in limine. He's going to make some rulings on what the defense can go into. We've heard that the plaintiff, Maya's attorney, said, hey, I agree. I won't bring this up again. I promise. I just don't want you to tell the jury to disregard this, because then they're going to view me as, I'll be diminished in their eyes. And so it's extremely complicated. Obviously, there's a ton of money at stake here with, a $200 million suit going on. So this is the in-depth lawyering that is going to happen, that will lay the structure for what's going to be happening later on in the court. So if there's a motion later on about this, if there's an objection that comes up, and defense says, Your Honor, we object, that was in limine, or something like that, they're basically saying, we're referring back to this day. Remember, we sat in court and argued these issues back and forth, and that day you ruled that XYZ is allowed, but ABC was not, and they're going into ABC now. So this is the foundation. It's very heavy, but it helps us understand the events that happen later on. Okay, any questions, or is that close enough? Let me see if we can get some sound coming in here.
Impulse
there we go.
Is. And the case law on that comes more from the state of Mississippi than from other places. And it tries to draw some fairly fine distinctions between mental conditions and mental illness. And that if it causes a mental illness rather than a mental condition, that may be enough. And they use that language to basically explain that
Ryan, that doesn't sound fun.
Uncontrollable impulse. So in one of those cases,
so sorry, man.
Let's see if I can find the language here. The court actually goes to the testimony and says that the plaintiff's psychiatrist, Dr. Barnes, stated that if you ask Schomburger, the plaintiff what he was going to do before he committed suicide, he would have said he was going to kill himself, and such acts were voluntary and with the knowledge of the consequences of his act. And as a result of that, they found that it did not pass a test where it would be sufficient to be a claim for intentional infliction. And the language that I have sorted through on this, that I think comes fairly close to the other cases that have this irresistible or uncontrollable impulse, would be that she did not have the ability to know what she was doing. And so that the instruction that I have given at the end, let me read the language here, is that in order for All Children's Hospital to have acted with reckless disregard of a high probability of causing severe emotional distress to Beata Kowalski, resulting in suicide, I'm reading the wrong one. For extreme and outrageous conduct to be a legal cause of suicide, the extreme conduct must have caused a mental illness that resulted in an uncontrollable impulse to commit suicide.
The other side says
The uncontrollable
Florida law doesn't
impulse
require
must
mental
be
illness.
sufficient that it can be said that the plaintiff did not have the ability to know what she was doing, so that she could not stop herself from committing suicide. And I believe that is better than the language that they have suggested, which is in a paragraph that actually begins in other words. It was just kind of a colloquial restatement of what Nelson was holding would be the cause of action in that. So those are the three positions that I'm taking on the jury instructions.
Mr. Elegant.
Yes, Chris, could you tell me what, I think you didn't have the docket and index number, but what date that was? I think I missed that.
It's 3346, DIN 3346.
Oh, okay, that's bad. Okay, let me write that down. 3346. Well, rather than get into the detail on it for the moment, here, sort of working backwards, but could not stop herself. The problem with that is, Your Honor, that we don't think that reflects all the circumstances, and particularly the circumstances in this case. Here, and again, I admit to being the least knowledgeable of this, but my impression is that the plaintiff's position is going to be, she concluded this was the only way. This was the only way her daughter was going to get released from what she thought was an untenable situation. And that's, is that uncontrolled, is that couldn't stop herself? That may be, hey, look, I mean, it would be like a person that had extreme debts and he's worried about taking his family under. He says, but I've got $1 million worth of life insurance and the suicide exclusion is past that. I'm gonna make my family rich. I mean, that's not couldn't stop yourself. That's in a sense, a logical, outcome. So that's a problem I have. Second, the Nelson case is a comp case, but it's then cited by the federal court, Middle District, in 2008 in a state of Duckett versus CNN. I think that court thought it had broader application. I think that if Your Honor could give us some guidance, and I understand not wanting to roll from the bench on this, because I would agree it's an involved issue. I think if you could give us some guidance and say, and not necessarily at the moment, but say, look, I'm not going to require a finding of that she was mentally ill, or I am going to find it. I am going to require that. And again, our position is Florida law doesn't require it. But I think if you
they don't
told
want that
us
mentally
that,
ill thing because
you could rule on that narrow point.
Beata didn't have mental illness diagnosed.
I would be hopeful that Mr. Altman and I could work out some language and
Kenny,
at least
I'll
give
try
you
to address that in
instruction
just a second.
that if it wasn't agreed to, it would have, okay, here's what we want, here's what they want. And then you could make those choices.
If the judge rules that the mental illness line is included in the jury instruction,
you're suggesting that the law should recognize or does recognize a person who rationally decides to end their own life as able to, or her estate to collect for a rational decision to die by suicide?
to collect from someone that drove them to it, to make that to where they said, this is my only chance. Now, you and I might not say that's rational, but that person might have thought it was. In other words, getting back to, and I guess one other point, I don't think, and I think this goes to your question, I don't think the defendant has to have intended that the person commit suicide. I think I heard that as one of the arguments, and that may be the one that you didn't agree with. But anyway, because you could do something that's so, and the idea that the person may commit suicide never enters your mind, never enters the defendant's mind, but they still do these things, and that's a foreseeable outcome. So, I mean, I don't think I'm
worried the plaintiff's going to lose this point.
I think we would all, I would hope we would all agree that there are better alternatives to suicide, and people ought not to do it, and that. But I don't think and again, it says had driven the deceased beyond the point where she could rationally decide against killing herself. So I'm not saying it has to be a rational decision. I'm saying I see people could get there without being mentally ill.
Okay, that's his point. He needs that mental illness to not be included in the instruction.
I don't mean to say that says it's a rational decision. I was giving an example where I think you could say some people could get to that conclusion. Now if it's somebody that's, somebody that's been, to use my earlier example, driven up their own debts, and they're, and now they feel at their wits' end, they've done it to themselves. But, if they...
Carol, this is literally in the allegation.
If they were being hounded by somebody.
Of the trial. This is literally what they're alleging.
Saying you got to make this right, you got to make this right. I'm going to put you in jail. I'm coming after your family if you don't do this. Then, have they been pushed to it? Is it still a rational decision? Maybe not, but...
Let me ask you this, Mr. Elegant, and I don't know the answer to this, and I have seen press reports about cases involving cyberbullying and a person taking their life. I seem to think that those were in criminal context, maybe not in the civil context.
Yeah, that's where the bullying.
But isn't that really what you're
drives them to that
kind of talking about? That
desired outcome.
That a person gets hounded so much in a la the cyberbullying that causes a person to take their life. And then I don't recall in those press reports any sort of necessary finding of the decedent having a mental illness.
Exactly. And yes, I think, Your Honor, that's one of the places we look for research on this, and I don't think we found a civil one either. I think there is a statute that addresses cyberbullying, so that's a little different. So I didn't think we would really analogize to that because we don't have a statute here. But yes, I think that is comparable. And if and again, did the bully intend a suicide? Probably not. They probably were just thought they were having fun and they were, picking on this poor person. But, so I think that's all in the same genre.
The hospital did not intend.
I don't think we have to have a mental illness.
I don't think anyone's even alleging the hospital intended.
If we have a ruling on that,
to end her life.
As I say, I think if we couldn't work out all the language, I think we could give you an instruction like we did a little bit earlier on the pre-opening ones that said, well, plaintiff wants this, defense wants this.
Mr. Altman, any further comments?
Yeah, 2 or 3 things. First, very quickly, the federal case he cited that followed Nelson took me a while to find it. It's not actually in Westlaw, but it was an order entered by Judge Terrell Hodges on a 12B6 motion to dismiss, emphasizing, by the way, that he was on a motion to dismiss and not a motion for summary judgment.
So that one is not indexed in Westlaw at all?
It's in Lexis if you have access to it, but I didn't have access to Lexis.
I don't think I have Lexis.
I could look it up on Google, and I did find it.
LexisNexis?
I'm sorry. I'll be glad to send it around. Sorry.
Could you send it to my judicial assistant? But there's enough Judge Hodges clerks running around that I'm sure we could.
It is on the internet because I did find it. What I can tell you about it is it's a case where a woman whose 2-year-old child was missing got talked into giving an interview to someone named Nancy Grace, who apparently was
Here's that
one
case.
of the people that
Who
puts
mentioned
things
this right
exciting
here?
on CNN News.
Right here.
And the allegations were that she ambushed her in the interview with false statements while she has a child that she's trying to find at that moment in time. And CNN announced to her they were going to broadcast it the next day.
Greeners,
So
you're on
hours
top of this.
Before that broadcast, she committed suicide. And Judge Hodges let that stand on a motion to dismiss. Well, that's very much one-on-one bullying with a person that you're seeing or hearing. I think it was a telephone.
So Judge Hodges allowed that case to proceed?
To proceed on a motion to dismiss. And again, emphasizing he wasn't ruling on a summary judgment in the order I read. And I can tell you from a bullying standpoint, and I have cited the case, there is a case from Illinois, Hankins versus Alpha Kappa, which is at 447 Fed Sup 3rd 672, Northern District of Illinois, 2020, where another case survived a motion to dismiss, but that was a girl actually living in a sorority house, and the sorority sisters were hazing her in a very extreme fashion, and they knew and could see that she was emotionally upset, and she committed suicide. My point, and by the way, I don't know that it ever gets prosecuted actually, but assisting suicide is a form of culpable negligent manslaughter in the state of Florida. I'm on that committee. We've never done a jury instruction on assisting suicide culpable negligence. The instruction just says, if you need one, you're going to have to write it yourself. So
nobody's gone there before.
I don't know how we jump exactly from the criminal law to this, but I understand there's a bit of a parallel. But all of those things have been where there was a mens rea, where people were intending to do something, or at least it arose to the extreme level of a culpable negligence for purposes of manslaughter. And that's really not what we have here. So I don't know that we can use that standard. And
I think
so,
the plaintiff's going to have a hard time
as Mr.
proving
Elegant has
culpability
explained,
for the
this woman
hospital
decided
on
to commit
this.
suicide as the only way to get her child released. She was in a situation where the trial judge wanted to have the dependency hearing a month later, and she didn't want to wait to win a dependency hearing, which they claimed she could have won if it had taken place. It never took place. But, you know, the decision she made was actually, I guess, effective, because the child was released by the court almost as soon as she committed suicide. It is, in my mind, an irrational decision, but it was something that she thought through in some level.
That's
and
the
so
strongest
I'm just
argument,
saying
that the
equating
outcome
this
was what
to
the mom wanted.
bullying, there's got to be some language that is more refined than that. And I think that if you reject my first instruction, that one of the second or the third come very close to the mark.
What I will promise is I will try to have some sort of thoughts to you by Monday as to where I am with this. I don't know how fleshed out an instruction will be, but at least I'll try to narrow the playing field such that we can proceed further.
Because and that would be very helpful, because that way we know what is relevant and irrelevant to some degree going down the road.
Well, I appreciate this conversation, because this has also been helpful for me to help frame where and how I'm going to be looking at this.
This is very cordial.
It's about almost 11:30, and you had indicated that you didn't mind if we ended early. So although there's other things we could go on to, it may be a good time to stop this. I do know we had at least one or two trial concerns that we wanted to bring up, but I guess Greg's not here.
Without Mr. Anderson
Mr.
being
Anderson's
here.
not here. We shouldn't do that.
Yeah, that was my thought.
Well, is it something that you can at least let Mr. Elegant know that they can relay?
Sure. So
that you can at least be thinking about it?
Yeah, sure, Your Honor. There's it's back to a skilled witness issue. Dr. Napolitano, for example, he was here as a corporate representative. He gave a deposition, and he was a member of the Risk Management Committee. His deposition was narrowly tailored and ordered by this court only to address Risk Management Committee issues. Plaintiffs want to play his deposition. We believe he's not a skilled witness. He may be an MD, but he didn't have any clinical involvement with Maya Kowalski. He's actually a neonatologist. His role and function was simply to talk about risk management committee issues, and for that reason, we believe that he's not a skilled witness. He should come live. And I would point, Your Honor, to Your Honor,
he said something in the deposition they don't like.
3361, where we addressed a similar issue, where we had a licensed mental health counselor and an RN, but both of those weren't functioning as RNs, or they weren't functioning as a licensed mental health counselor.
It's going to be
we believe
hearsay.
Dr. Napolitano fits
Mandy.
within that. He's ready, willing, and able to come testify.
It might be very difficult to get that note in.
This court's also indicated that we didn't want this trial to be hitting play and playing depositions a lot, so we think that Dr. Napolitano, whenever they decide to call him, should be here live and not played for the same reasons and logic set forth in DIN 3361.
So Mr. Elegant can relay that concern, and we can.
I've talked with Ayden.
If y'all can't work it out amongst yourselves, then I'm sure.
I don't have anything to share. If you're worried about him, some thoughts and prayers his direction would help.
There's also an attorney, Jackie Crane, that falls into that role, but we can discuss those issues later.
Anything else that you all want and or need from me at this time?
I think I'm going to make
Mr.
Mrs.
Elegant's
R.A.
on
read
Zoom in
the whole
front of me
complaint.
right now. Can I ask him whether there's a good time I can set a Zoom for this afternoon for us to meet?
Yes, I have something at 1, but I'm sure, let's put it away. If it's not done by 2, I'm going to leave anyways.
All right.
Judge,
you're not his 1 o'clock appointment.
One thing, just sort of an observation I would make on the suicide, the intentional infliction suicide, is that, and I agree this is a complicated issue or challenging issue, whatever. I think one thing we can all keep in mind maybe as we head toward the end of the trial is there may be a way to deal with some of these things with a special verdict form, and not necessarily
thoughts
just
and prayers right
that
now are the best
instruction,
thing
but
we
some
can do
of
for
the other
Ayden.
stuff. I mean, I appreciate the verdict form is probably going to be a significant anyway, but.
Well, let me reiterate my comment. I don't even remember when I made it, but to the extent I can have interrogatories that will prevent us from having to try an issue again, even if, we might not agree that something needs to be found, getting the interrogatory response is going to be helpful. So to the extent we can logically make that happen, I probably want to craft them to allow that to happen.
Interrogatory is a written question which is formally put to one party, which must be answered.
With or against one another for a long, long time can help you with that.
And I appreciate both of you. I know it's
James,
not easy.
who would they bring the letter through? I mean, how would they present this evidence?
Anything else?
No, Your Honor.
That's good.
We'll be in recess. Have a good afternoon.
I'm just
Thank you.
okay. As we're done there. First of all, that was very important testimony, but it was not nearly as spicy as I thought. So I apologize for that. Let's see. First, if the note was written by someone who can't testify and can't be crossed, that's not fair to the court. Think of the Mark Jensen trial, where he got a retrial. He won an appeal because the note, literally the note that was written, almost like a suicide note, but it was if I die, it was my husband who did it note, was deemed not admissible in court. So I'm just wondering how they would get that in. It would be interesting, very interesting if it did come in, because it's pretty damning. But I don't think it would be fair to the hospital, who has the right to question the witnesses against them as well. Let's see, where are we at for? I owe Kenny an explanation. He had said some really nice things about my channel, and let's see, where was the question here? Scrolling. I apologize. We're going to find it. Kenny had said something about my background or something like that, right? I have loved the law since I was a kid. When most kids were barely getting into reading fantasy novels and things like that, I was checking out legal books out of the library. If they would let me, most of them were reference copies, so I'd have to go to the library and sit there and read them there because they wouldn't let them leave the building. I loved reading state law. I loved reading the proposed law. If we're talking about legislature, bills in the legislature. Loved going to court, even if it was just down in my little community at the little city court, and hear traffic court and very small matters like that. I've loved that since I was a kid. Professionally, my background, I went to school for communications, electronic media, so I worked a little bit in the media that way. I've worked with television. I've done some filming for police. I've done some work with them. I've loved involvement with the law enforcement, even though I've never been employed as a law enforcement officer in any capacity. The way I made my money, though, because those professions, as much as I loved them, were not very lucrative. The way I made my money was in IT, doing computer work for the Department of Defense, which I did up until little over a year and a half ago, I think, and that's when I completed my last contract with the Department of Defense, and spent about 7 years looking for a job. Or sorry, 7 months. 7 years would be a long time. Sorry, Miss R.A., give you a heart attack. But 7 months looking for a job, and in sort of frustration and a little desperation, not being able to find something that would allow me to stay where I wanted to be, which was here in North Carolina, and do what I wanted to do, which was the same work I was doing before, which paid very well. I started a live stream, and we live streamed the case with Daryl Brooks. And started with 13 people the first day. Next day was like 35, 45 people. Next day was 350. The next day we had 13,000. So in 4 days, it sort of exploded. And I thought, this might be something I could do. I love doing it. I love combining what I've learned in school with all the production side of things, with cameras and switchers and audio and everything else. I like using that and bringing that expertise into the courtroom to help out to make the viewing better for people who are watching. I do a lot of tweaking of audio to improve the sound. I'll remove background noise, and so we can hear things a little better. And I like to find multiple sources and as far as video feeds and run those through a switcher so I can show you different things at different times. Anyway, with all that said, that's my background. I am not a lawyer. I just play one on YouTube. but I love the law. I've studied for a long time. I think eventually, if the time's right, I just might take the bar exam. I'll have to move to Virginia, where I don't have to go to school before I take the bar. but that's where it's at. The name Recovery Addict, I think you might have asked something about that. I started this channel as a metal detecting channel, where I was addicted to recovering artifacts from the ground. And I love metal detecting. It's one of the best hobbies in the world. It's like dirt fishing. You never know what you're going to find. I have way too many metal detectors, as Mrs. Ray can attest to. But I love that. I started this channel, I think, 2017 for metal detecting.
Do you solemnly swear or affirm the testimony?
I don't, sorry. This is an old video. Anyway, I started that in 2017, and then between then and about a year ago, I had collected about 600 subscribers on the channel, and through all my efforts in all those years. And then in 4 days, we got well over 1,000, almost 2,000 subscribers, and it's just grown. We're now over 40,000. It's grown very quickly. It's been amazing. I will tell you, I'll be the first person to tell you, I have no idea what I'm doing. I'm learning this sort of trial and error. The YouTube side of this, I've been a consumer on YouTube for years, but a lot of this I learn, and the people who've helped me out the most have been. You'll see them, their names in blue on the chat, and they're incredible moderators who have walked this path before with other creators who have experience and expertise and are extremely patient and generous with their time. The moderators have really helped me through this journey into YouTube, and I've loved it. It's been fantastic. I stumbled into what is arguably the greatest community online, which is those who like true crime, or as yesterday was, just crime. But as we watched the riots in PA last night, but it's an amazing community. We try to treat everyone with respect here and share opinions in a respectful way. And as long as we can have that open dialogue without the yelling and without the bickering, we can all learn together, and it's a better process for everybody. So hopefully that answered all your question. I'm sorry I made you wait this long for it, but it's good to have you here. I would not be the same without you. I appreciate your question. All right. Am I missing any questions does anyone need any clarification on anything? I was going to talk a little bit. The last portion that we heard was just with the Zoom lawyer and the lawyer.
I'm so glad you are explaining things. I'm popping in and out, so I appreciate you doing this. Maya and her family deserve justice after 5 years. Red hard, red hard.
Kayla, thank you very much. I appreciate that. I hope my explanation helps. I will tell you that I've been taught. I have a shirt that says, it was sent to me by Matthew Harris, and it says everything. I asked him for this. Everything I know about law, I've learned from Matthew Harris Law. But it's not true. We also have Nicole Goodman, who's here, a good friend of the channel as well. Both lawyers who have been extremely generous with their knowledge and time. I've called them on and off the air and asked for guidance and help as whether it's my own legal issues or questions that we have as we watch trials, and they've just been there and helped out a ton. Just having people like that, and not just them. We have people from public defenders' offices. We have people from we have prosecutors. We have people who have been involved in law enforcement and capacity, in those capacities, that are all here, and they bring their knowledge into this little community. And as we discuss things openly and in a polite way, just being kind, we're able to just gain collectively a lot more knowledge. My mind is like a steel trap. There's nothing getting in there. I'm not just kidding. Sometimes some things stick, and for me it's easier to remember laws and things like that than other things like names. I have a very hard time with, I admit, but I just love it. This is something I really enjoy doing. So, Kayla, I'm glad we could help. Talking about the last little bit of, let me go full screen. I'm awake enough you can see my face now. Talking about the last little bit of testimony we heard from the lawyers. This is talking about a jury instruction. Jury instructions are the last thing the jury hears before they go out and deliberate. And so you wonder, why is there so much fighting about this now? Well, if they can, the jury instructions are like the rule book that the jury gets to usually take with them or have read to them right before they go deliberate. So it's a reminder of, here are the parameters where you can play. If you had never played rugby before, okay, and you wanted to participate, or you were asked to participate in a rugby game, imagine having a rule book where you could read through and say, okay, here's this play, here's what's going on right now. Let's stop and think about, what am I allowed to do and what can I do? And you check the rule book and like, oh, that explains what I'm supposed to do here. And then it will allow you to participate within the rules. The jury instructions are like that. They're right before they play, and at any time they can stop and refer to these jury instructions. They're like, hey, we're supposed to figure out something about whether the hospital is culpable in Beata's suicide. And what's the jury instruction on that? There's going to be an instruction to the jury specifically about that, saying if you find XYZ, then the hospital would be culpable or have some responsibility in this outcome. The hospital would love for that jury instruction, that rule, to say there has to be mental illness. There has to be a mental illness found, because I don't believe that Beata was diagnosed with mental illness, and that if they can just slip that little bit into the jury instruction, it basically means there's no way under the rules that the jury is given to operate that they're going to come back and say, yep, you're liable, because that mental illness piece is missing. So there's a huge outcome that's playing on this little bit of back and forth. Anyway, it's very detailed. It's very in the weeds, but it means a ton for the outcome of the court. And the hospital has won a lot of these battles. And I will say again, even though the hospital is winning these objections, I think it's because the law, and I think Mr. Apatorso was saying this, the law seems to be on their side, whether you like the law or not. They're finding case law, they're finding law that supports what they have done. And that's why they're winning these objections. So I think the judge is still being impartial on that. All right. Anything else? Is the CPS order in the complaint? Ooh, that's a good question. The complaint, the one I found, let me see if I can, I'm not sure if I can share this because it's drilled down into the, hey, Mrs. R.A., welcome. She says, I keep asking questions, you keep ignoring me. I'm so far behind in chat, that's why. Let me see if I can post this link. I'm going to post it and just one person try it. It's a secure link. Does that go straight to the complaint for anybody? Let me see if it works for me. It might error out. That should get you straight to the 90-page complaint. There it is right here. Hey, Mrs. R.A. has a question. Do you want to? And she's very tired because she was up late last night moderating the riot stream. I'm so sorry.
I know. I'm so tired right now. Hang on. One sec. Sorry, yawning in your ears. Okay. So I just haven't been able to follow this very much because I'm doing school and all of that. But I'm trying to make sure that I understand. Is this actually what's going on? That Maya was brought to the hospital by the mom. The mom, then they look at it and they say, hey, you're asking for medication that's really bad for Maya. You're a terrible mom. You're not allowed to see her at all. CPS, we're going to call you. CPS says, sure enough, she's a terrible mom, so they're not allowed to see the daughter at all for, 90 some odd days, at which point the mom says, if the only way to get her home is for me to get out of the picture, I'm going to take care of that myself. And then the hospital releases the daughter. Is that right? Is that right? What the freaking heck? Is that the case?
That is the allegation. That's pretty much the allegation. And it's, as a parent, it's appalling.
Oh, that's beyond appalling.
But you have to look at this as well on the other side. The hospital has duties. They have obligations. They are required to report. They're mandatory reporters in cases where they suspect that there is abuse. There's something going on. And they had one person, I think Smith was her name, that suspected that the mom was the cause of this. And how can you get a court order without proof or something?
Hang on. Okay, no. No. Okay, let's just turn this around for just a second. Let's say that a mom or a dad goes out there and says, hey, I think that the doctor is the cause of this. I believe that the doctor's doing something wrong. I'm going to do something completely drastic and separate the doctor from their family because what a horrible person this doctor is. Are you kidding me? Are you telling me that because one person said there was a problem, all parental rights are severed? Who the heck is in charge of this? I did not get enough sleep.
I'm going to take mic privileges away from Mrs. R.A. She needs a nap. She's a little bit hangry. It's a huge issue, and we've only heard one side of this, right? We've got to hear the hospital side, and literally we've got to hear the laws that the hospital is going to argue and the reasons, because the only reason they went to court is because they feel they could prevail in the minds of the jury by convincing them that everything they did was in the best interest of the child and according to law.
Is that correct?
Okay, if they don't believe that, they're literally walking into a trap that will just cost them untold millions of dollars. They have a belief that they can prevail either legally in these little battles back and forth to exclude evidence and things like that, which they so far have done fairly well at, or that they'll prevail in the minds of the
bombs on us. Yes.
Sorry, Mrs. R.A. dropping the yes. Nicole Hernandez, yes, you're welcome to email me. My email is on the about page of my YouTube page. So if you click on my channel and then scroll over like the little buttons across the top, all the way to the right, one of them says about. And that's it. So I'm gonna talk with Mrs. R.A. off the air after she gets a nap.
That's still right.
I'm afraid she's gonna strangle me if she doesn't agree with me. Mrs. R.A. just said everything I'm thinking, says Ocean Girl. Yeah, this is a tough case. The issues are huge. I mean, as somebody, and Mrs. R.A. and I are both on the side where we believe that government involvement should be minimal, and usually government involvement wastes time and money, and oftentimes intrudes on rights that they should not be intruding on. Not all the time. I mean, some of the CPS, there are times when we say somebody should have done something. I mean, look at let's look back. Josh Powell. Okay, this is the Susan Powell case. If you guys followed the case of the mother who went missing, the husband went out camping with his daughter and son, his kids, in the middle of the winter in the desert, and came back and the body was never found. Changed the mattress, was thrown away. Everything. In that case, those two kids were killed by the father in a house fire. I believe that was up in Washington. Oregon or Washington, when literally the CPS agent was delivering the kids to the dad for visitation, and she was there in front. He grabbed the kids inside, locked the door, and lit the place on fire. And we're looking at that and saying, CPS should have done more. There should have been. We sometimes we're on one side and sometimes we're on the other, and there has to be a line, and it's a tough decision, saying where that line falls. Lots of things. Tell him this is already to take a nap, and I got the Low Country Boil for lunch taken care of. Oh, Low Country Boil. Tag. I have never had a good boil. I'm not talking crawfish. I'm talking like blue crab or anything. I've never had one. I've ordered some food once, and I just ate the shrimp. I don't know. I want to. I was watching videos of this last night, and my young little boy, my 8-year-old boy, was like, "Oh, that looks so good." When he's watching people, picking crab meat and stuff, he wants to try it. So I have to try that sometime. Yes, Mrs. Ari does have her own YouTube channel. It's focused on homeschool, and it's called Homeschool Ground Zero. Thank you for that. There's my email address. Thank you, Sharon. I appreciate you putting that out there as well. Let's see. He blew up the house with a social worker there. Yeah, that was a crazy case. Amazing podcast on that one. Who was it? I don't remember the. Is it Ethan? One of the reporters from KSL, one of the radio reporters from KSL, did a podcast, and it was a cold case podcast that was unbelievable. I think it won like millions and millions of awards. Looking into that, and just the access he got was unprecedented. All right, we are. Let's see. Amber says, Mr. Ray wants to chat with you. Can you steal the burner? Okay. Sorry, Amber. I was disregarding the phone. It was buzzing, but I wasn't paying attention. Let's see. Never heard of a Low Country Boil. Well, now we have to go search YouTube and do that. Better homemade than in a restaurant. I would love to. I need somebody local to invite me to a Low Country Boil and teach me how to eat this food. It looks so good. Let's see. We are done for today. We don't have anything else, which is good because we stayed up all night last night with that riot. So I apologize if we're done. Mrs. Ari has incredible self-control. Very, very few times I've heard cursey words from her, and when she does, they're so cute. Let's see. A Low Country Boil says I make them with snow crab legs, shrimp, sausage, potatoes, corn on the cob. I use Cajun spices. My son polished it off in 2 days. Boom. Yeah, it's basically all the good stuff boiled in a pot together, then dumped out on a table, and you just feast. At least that's how it looks in the videos. All right. Anything else we need to cover? Where's Maisla? Yep. Okay, there's a ton of details here. I appreciate. I'm not following all the discussion back and forth. It's amazing having so many people in chat who have some familiarity with either this syndrome, with the Child and Protective Services, with a hospital that's had a similar action, or they've fought for a diagnosis that medical professionals were resisting. Just crazy. The riots it seemed to sort of peter out towards the end as a lot of people were taken into custody. There was one video that we showed where there was a woman that was sort of holding the phone selfie style, so you could see her, and in the background there was a wine and spirit store, and she was yelling, "People got to eat! People got to eat! People got to eat!" She is I believe an Instagram influencer. I was told her account, she's known by the name Meatball. She was arrested live on stream. As she was sort of cheering on the events. I'm not sure if she was involved in any theft, but the police did take her into custody last night. Yes, and at the end of the day, we're all still friends. That's what makes this so much fun here. Yep, KQD, thank you for being here. Good to see you as well. All right, there's my email. If you need to email me, I read it every month, whether I get emails or not. I'll try to check it if I know something's coming. Crabfest 10-7 is exactly what Low Country Boil is. Just the men, no wives allowed. Hey, what's up? Are you going to take lunch break or do you We're going to wrap up before lunch here. We do have a video on the riot. We posted it last night. Thank you very much. I appreciate that. All those who were able to join. I'm sorry I kept you up and away from sleep. I do have Star Wars equipment right here. That's where it is. I can launch fire from the Death Star. Let's see, do I have a Death Star sound? I don't think I have a Death Star sound. That's about the best thing I have. So anyway, that's a little pathetic sound effect for Star Wars. But let's see, I didn't get notification for the riot stream. It's all right. You should have slept through it. It was very late. New York serial apprentice in court today. Lots of things to follow. I'm very tired. I don't think I could follow another case today. We're going to take the rest of the afternoon off. We'll be back tomorrow. Court starts again tomorrow. I think he said 9 o'clock. Are we correct on that with the Maya case? I'll be watching for looting tonight. Yes, I'm not sure if it'll happen again. One of the key factors of the looting and the rioting that happened last night was that there seemed to be an organized crime ring, like a theft ring, that sort of instigated this or put information out to get people involved to cover their organized theft and break into stores. So they would lead and use the crowd as a cover. I think they got arrested, or a lot of people got picked up in that. So hopefully that's done. You have a LexisNexis coffee mug. Is it LexisNexis they were talking about when they said it's not on Westlaw, it's on Lexus? Where were the riots? They were in Philadelphia, Pennsylvania. Will you be back? I'll be back tomorrow morning, and if there's something tonight, we'll do that. On my agenda today, I've got a blind to hang up in one of the bedrooms of our Airbnb, which is so close to being done. The countertops are in. We did a vinyl pour on the countertops, and it looks like a sort of like a white with gray marbling in it, and it looks beautiful. So that's in, but it needs to set. It has to set for like a month. It's crazy. So that's in. We need to cut the countertop or cut the hole for the sink in there. We've got to put that in. I've got the blinds to put in. We've got a little bit of floor trim to go in. We still have all the bathroom tile to do, the backsplash, the tile in the kitchen as well. A little bit of border around a window. We're getting so close to being done. I'll have to do another walkthrough here once we get a little bit more done. We do get the rest of the day off. Mrs. RA gets a nap, so whatever I do, I have to take the kids with me and do some, like a school excursion or something while she sleeps, because she was up late. All right, I think that's it. We've hung around longer than needed. It's lunchtime. We've had a lot of fun. Thanks for sticking with me today in this case where it was no jury, only one defendant was there. I'm going to read through some of this 90 pages of the complaint to see if I can pick out some key parts. And I realized we're looking at the original complaint, and there have been, 100 or so modifications to that as things have been ruled on, and ruled in and ruled out since then. So even though we've got the latest version of the complaint, it has been marked up a lot since then. It's very difficult to have the latest and greatest. All right, that's it. Thank you, everybody. I'm going to do a little bit on Twitter as well, because last night we had a audio. Let me see if I can play this for you. Last night there was audio during the live stream, and this might really this might surprise some people. Let's see here. Let me kill the music. Stop. Kill the music. Let me bring this up. Last night we were listening to the police audio of the riots and what was going on there, and during that audio we heard a transmission that seemed very disturbing. An officer speaking to another officer. This came across on the PPD, so Philadelphia Police Department, 14th District Tactical Channel, which is one of the channels where this audio was coming through. I posted, or Nick the Hat posted it on Twitter. I've got a cleaned copy I posted. Then last night, after the stream ended, I grabbed all the events that happened on that channel. So I filtered out everything else, and so I wanted to see in context what was transmitted. Unfortunately, there's not a lot of context. There's nothing really before it. But if you listen here really carefully, I'm going to play this for you guys so you guys can hear what happened and let you think this over, because this is pretty disturbing.
Shut up, Brad. Tommy, you might get your wish to beat up some little kids in a couple minutes.
He can't wait.
How mad are you you can't go over there and get this fucking car stopped?
What the fuck are you doing?
Terrible. Hey, Sarge. We just chased out like 5-6 cars out of this Robinson down here. They all took off down Alney towards Broad Street. Like a bat out of hell. Good. That's not our fucking problem. I'm pulling up right now.
Okay. So sorry about the language there. But this transmission, specifically one that says you might get your wish, get to beat up some little kids, concerned us. We do know that last night that audio recording was taken. I believe Nick took that, sent it to the mayor and to the police department for public relations, and they're looking into it, and we're looking for an answer on that. So we're going to keep an eye on Nick's feed for that to see if we get a response for some context or exactly what was going on there, because it was not good. I can't imagine a scenario where that sort of transmission is okay. There's also the whole factor that, you know, I have a ham radio license, and I know the laws according to the Federal Communications Commission, swearing over radio waves is not legal. It's not legal. The internet is not radio waves, so that's okay. But swearing over a police audio is very it's prohibited, and the language there is not good. So we'll see what happens. There's Nick's channel. He was awesome to help us out last night. Thank you again. Anyway, so that's how we're going to end it. On that note, I'll let you think that over and what you think about that. Let me know in chat or in the comments. So it sounds bad. Hopefully, man, the videos we saw, there was quite a bit of violence on both sides. And Pickles not politics, so I don't know how to wade into this without that. Ugly Betty, I'm only a technician, no code. I realize I got it when there was code, and now code's going away. But all right, so on that note, we're going to wrap things up. Let's see, another reason the union will want encrypted comms only if the public gets them in trouble. Okay, if they're doing something wrong, hiding it is not going to help us. It's not going to help the problem. And now cops will push that all radio communication is encrypted. They already try. Even in cities that have encrypted radio, the news stations are able to gain access to that and listen. They have basically a decrypted radio using with permission through the police. They're able to still listen to that. So it won't be available on public, but the news should be able to get it. Anyway, tonight, when you go home, please hug the people you love. Smile at someone, make their day just a little bit better. And please stay safe till we go live again. Tomorrow morning, I think we're going to do 9 o'clock. It might be 8:30. I'll have to watch and see when court starts. But watch for the little window. First in chat, as always, wins the internet. Thank you for our new internet owner today. I can't remember who it was off the top of my head. The first-time offender. Whoever you are, you did a great job. I'm sorry I forgot your name. I'm awful with names. Anyway, we'll see you tomorrow. Have a great afternoon. Have a good one. Bye.